family looked like, no matter what the student looked like, the better outcomes they had. Please vote yes.
Further remarks? The good member from the 49th District, Representative Stonier. The House will be at ease.
Bernie Whitebear was the first person that ever talked to me about urban Indians. We spent time together on the streets of Seattle, and he would say to me, Ralph, these people need a home. They need some place they can go and they know they're safe and they can gather and sometimes could receive maybe medical care or maybe find out more about their own tribe back home, whatever it happened to be. They were from all different tribes, and some from Alaska, some from British Columbia, some from here. And they often found themselves on the streets in our major city of Seattle. Bernie had read the treaties, and he knew that a number of the treaties between the military and the tribes had said if the military ever gives up tribal land that they'd take it from the tribe, that the tribe had a right to take it back. And based on that language,
consideration of Amendment 1157. Remarks, Representative Stonier.
Thank you, Mr. Speaker. I'm asking you to vote no on this amendment to the language at the beginning of the bill. Much of what the good gentleman said is absolutely true, and the part of the amendment I have concern with is the part that says that this Initiative 2081, as you know, having voted on it last year, went to the legislature and was not a measure that was put before the voters of the people. So please vote no on this.
Further remarks? The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. This is an essential amendment. Please vote yes. Mr. Speaker, parents are the primary stakeholders in the upbringing of their children. Let me say it again for emphasis. Parents are the primary stakeholders in the upbringing of their children. This language was essential to the law that we passed last year. It is unfortunate that we would consider removing that essential language from our state law. Now, of course, in this amendment, we recognize that parents includes legal guardians, and that's important. Because, Mr. Speaker, it doesn't even matter if the parent is a biological parent. But the fact is, Mr. Speaker, and the science backs it up, that children who have clear authority figures and caregivers and people who love them in their lives have a greater prospect for prospering in our society, and really, Mr. Speaker, in any society. Parents are the primary stakeholders in the upbringing of their children. That is the reason to vote yes on this amendment, Mr. Speaker. It is essential. It may be as important as everything else that comes after it in this proposal. The parents of this state know that this is true, Mr. Speaker, and they are waiting for us to recognize that truth and waiting for us to maintain that truth in our state's laws. Please vote yes.
Further remarks? The good member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker. As we heard earlier in this discussion, as you and I heard, this ballot title may be somewhat, or not this ballot title, but this title may be somewhat misleading. It's something that was objected to, but at this point, the least we could do is provide clarity as to the intent of the bill. I am asking that we support this amendment so that we can ensure that there is clarity as to why this legislation should move forward and what it will do. So I urge its adoption.
Further remarks? Seeing none. Oh, the question before, excuse me. The good member from the 37th District, Representative Santos.
Thank you, Mr. Speaker. Just rising, asking for your no vote. You may have heard on this floor that the underlying committee amendment removes an assertion that parents are the primary stakeholders. One of the things that this amendment before you does is it adds to the existing language that, if I may read, Mr. Speaker.
Please proceed.
States that the legislature finds that parents are the primary stakeholders in their children's upbringing. So we have not removed that. We retain that as the opening sentence in the underlying amendment. I ask for your no vote on the amendment to that statement.
Further remarks? Representative Defoe.
Thank you, Mr. Speaker. Asking you to support this very important amendment. The good lady from the 48th talked about the voter process. Well, what happened was almost 500,000 voters signed the initiative request form, the petition, and submitted it. So they did, in fact, request the legislature to act on this. That's how Washington state law works, Mr. Speaker. When the voters put forward a petition, it has the requisite number of signatures, then the legislature has the opportunity to vote on it, which is in fact what happened, and we passed it. Now we're here undoing it under a less than transparent title. And so what's very important is that we include this amendment that recognizes the fact that almost 500,000 people, or well over 400,000 people, voters, signed this initiative and brought it forward, and that the regular folks in Washington state know that it's common sense, and we want to see it validated that parents are the ones who are in charge of their kids. A very simple concept, something that needs to be amplified in this chamber, and something that needs to be amplified through this legislation, so please vote yes.
Further remarks? The good member from the 6th District, Representative Graham.
Thank you, Mr. Speaker. I'm rising in support of this amendment. As an individual that grew up in Washington State and attended Washington State public schools, also a mother who sent her children to Washington State public schools, something has drastically changed, Mr. Speaker. I remember a time when parents were working with teachers for the betterment of our children. What I see happening right now today separates families. It separates parents from being able to be involved. Mr. Speaker, we had situations where there were school board meetings and parents were being put on lists of being domestic terrorists because they wanted to be involved in their children's education. There's also an issue of government overreach, reaching in to the homes where parents have a right to raise their children as they see fit. Mr. Speaker, this amendment is vital. It is absolutely in concert with respecting the will of the people that signed their names on the initiative. We should respect that, Mr. Speaker. Please vote yes on this amendment.
Further remarks? Seeing none, the question for the House is the adoption of Amendment 1157. All of those in favor say aye. Aye. All of those opposed say nay. Nay. The nays have it. The amendment is not adopted. Further amendment, Amendment 1161. The clerk will read.
On page 1, beginning on line 19.
Last line.
Or on paper.
The good member from the 8th District, Representative Connors, to move adoption of the amendment.
Thank you, Mr. Speaker. I move to adopt Amendment 1161.
It has been moved and seconded that Amendment 1161 be adopted. Remarks, Representative Connors.
Yes, thank you, Mr. Speaker. The initiative that was brought before the legislature that was passed by the legislature last year included that the parents could get a copy of their children's education records within 10 days of asking for them by request. The underlying bill has changed that to 45 days and has deleted out medical records out of that provision. I think you'll hear another amendment about that in a moment. But in this particular amendment that I have, it states, if I may have permission to read,
please proceed.
That the education records include a child's cumulative folder, such as general identifying data, records of attendance and of academic work completed, records of achievement, results of calculative or evaluative tests, disciplinary status, test protocols, and the one that bugs me the most, Mr. Speaker, is the individualized education programs, the IEPs. These are medical programs for our children. You may not know, Mr. Speaker, but I had a daughter who was on an IEP. It maybe didn't last her whole educational career, but it lasted a period of about 6 months. So for me to be able to get a copy of her IEP, to be able to take that paperwork to her doctor, to be able to take it to, for her to be able to do programming that was paid for by the school, having a special tutor to come to our home when she couldn't go to the school. It's really important that folks that have their kids on IEPs be able to get those records in a timely manner. As a matter of fact, if I might have permission to read one more time, Mr. Speaker.
Please proceed.
In RCW 70.02.080, upon receipt of a written request from a patient, this is talking about medical records, to examine or copy all or part of a patient's recorded health information, a healthcare provider as promptly as required under these circumstances, but no later than 15 days must respond to somebody on a healthcare information. Mr. Speaker, I think that an IEP is healthcare information in many cases for many families, including mine. That's why I don't think it's an unreasonable request for a lot of this paperwork to be given to the families within 10 days as originally intended by the initiative that came to the legislature, rather than 45 days, which is in the underlying bill. So I am encouraging a yes vote on this amendment for those reasons.
Further remarks, the good member from the 37th District, Representative Santos.
Thank you, Mr. Speaker. Urging a yes. We tend to agree with many of the points the good lady mentioned, but I will also note that we have many hardworking staff members throughout our school districts that are already complying with the request to have their children's records on a regular and timely basis. This is especially true when you talk about those families whose students have IEPs. Those IEPs get regularly updated, and so parents are regularly getting this information. We're happy to accept this amendment. I ask you to as well.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 1161. All of those in favor say aye. Aye. All of those opposed say nay. The ayes have it. The amendment is adopted. There are further amendments. Amendment 1162, the clerk will read.
On page 2, line 34 of the striking
Last
amendment.
line.
Insert health records and records of any mental health counseling.
The good member from the 8th District, Representative Barnard, to move adoption of the amendment.
Thank you, Mr. Speaker. I'd like to move Amendment 1162.
It has been moved and seconded that Amendment 1162 be adopted. Remarks, Representative Barnard.
Thank you, Mr. Speaker. I really have 3 points I'd like to make. First is that schools under this law are taking the presumption that parents are irresponsible, and that parents, the premise of all these parents are that we don't trust them, that they're not going to do what's best for their children. This amendment, Mr. Speaker, allows that parents can go into their schools and for those children that are 12 and under, receive those medical records for their mental health, their physical well-being, and it is my responsibility as the parent to my children to make sure that they, for their upbringing and for their well-being. So there was a story, and I have a story very similar to this. I will share very quickly. That is that my son, when he was in elementary school, he was bullied. He received some medical care. There were things going on in our home that were also concerning to my son, and he was acting out in certain ways. And so he received health care. He received mental health care. He was written up, and it was very, very difficult for me then later to go back and ask what has already been done for him, how has this been dealt with, what can we do as far as I'm getting a hold of these records so that I can take a look and go take him to get the care that he needs and to further what the school has been doing. I wasn't given that information. They could have just redacted anything personal regarding other students or whatnot, but that didn't happen. I need parents that are responsible, that love their children. We should trust parents for the well-being and care of their own children to make the best decisions as far as their medical care, their mental well-being, or anything else that needs to be addressed. We know the statistics are already in. The facts already say that children do better in school when their parents are involved. I want to do what's right and best for my children in their care, and by not allowing us to have access to records is not acceptable. Please vote yes on this amendment. Thank you.
Further remarks, the good member from the 49th District, Representative Stonier.
Well, thank you, Mr. Speaker. Rising to ask you to vote no on this amendment. We have had this discussion many times. The last time you were presiding over a similar bill, we made it very clear that medical records are medical records and academic records are academic records. The comments that I've just heard are not inaccurate. When medical records and diagnoses and data are needed to be included in an IEP for a student, that then becomes a medical or an educational record that is not only discussed with teachers and counselors and other support staff, but primarily with the parents. And so much of that I agree with. In this case, I'm going to have to ask you to vote no because the medical records that are being referenced are not created in school environments. Because educational records are educational records and are governed by public school policy. Healthcare records are healthcare records. Those are not created by school personnel. They are included in documents like those we've just referenced. Please vote no.
Further remarks, the good member from the 8th District, Representative Barnard.
Thank you, Mr. Speaker.
The member has 25 seconds.
Thank you, Mr. Speaker. I just want to say, in my personal experience, that wasn't the case. It wasn't medical records. It was the medicine given to my son after this physical event happened on the school playground. So my experience was no, this was not an official medical record. And this puts in sync this bill with the federal recommendations.
The member's time has expired. The good member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker. I've heard a lot of discussion on this over the last few weeks, and I've heard that a lot of this is not happening in the schools, which is fantastic if it's not happening. The concern is when medical treatment, mental health treatment is occurring inside of our school facilities, and parents are not aware or are actively cut out of the discussion. I am pleading that you join me in voting yes on this amendment. And that's because if medical or mental health treatment is happening in our schools, whether or not it's being done by school staff or school personnel, parents have a right to know what's going on. We're not asking for any breach of federal law or any change to HIPAA requirements. This is just saying that if this happens inside the schools, that parents have a right to know that it's happening with their child. If it's not happening, fantastic. But if it's happening, parents will be aware of it. Please vote yes.
Further remarks? The good member from the 25th District, Representative Jacobson.
Thank you, Mr. Speaker. Urging a yes on this amendment. I do believe we need this safeguard because we are hearing from people who have felt that they were out of the loop and needed that medical information. Permission to read, Mr. Speaker?
Please proceed.
My son was, this is a constituent email, my son was in elementary school in 3rd grade in 2019. His older brother was struggling with drug addiction and had been arrested. Our family had many resources for the challenges we were working through. My son loved school and loved his friends and his teacher. After his older brother had been in jail for a bit, home life was settling down, but I noticed some major changes in my son's behavior at home. I assumed they were related to the struggles with his older brother, but he started wetting the bed, and he didn't want to go to school. When we would finally get to school, he'd cover his head with a hoodie and hang his head and droop his shoulders. He fought me daily about going to school. This was going on for weeks, and then we had his student-led teacher conference. Around the corner came his school counselor, and she asked if she could join us. I saw my son's countenance completely change before my eyes as we all sat down. She took over the entire meeting and told us she was very concerned about our son and some changes she had seen, and that they had brought in outside counseling for our son. He was refusing to do his work. I asked why I hadn't been told this before and asked how long he had been seeing this outside counselor. Her answer was 6 weeks. I asked her why they hadn't let us know or contact us if they were so concerned. I pulled him out of school immediately and started homeschooling him. But I also requested information on his discipline and counseling. It was a difficult process that took weeks with all the right wording, only to be told that they didn't keep those records. I asked who saw him and what the initial reasons were. They couldn't tell me. I have never received any further information or details on how he was disciplined, why he was disciplined, who the counselor was, or why they had a counselor come in. When the Parents Initiative was passed last year, I asked for it again and went through the same process. They refused. I saved all my emails. Thank you, Mr. Speaker.
Further remarks? The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Essential amendment to a flawed underlying bill. It'll make it a whole lot better. Please vote yes. Just listening to that story, if that child was in 3rd grade, that child is not old enough to give consent for mental health care treatment. So I'm not sure what was going on in that story, but if it's what the mother said it was, that school was breaking the law by withholding that information from the parent. That's why this amendment is so important, Mr. Speaker. We need clarity in our law. And parents and guardians need to know that they have the right to know what medical, what health care, what mental health care services are being provided to their children. Now, we can hear, well, this mostly would happen in the context of an IEP, and that's true in part. Doesn't matter. I've had parents in my district talk about how they can't get all the details of their kids' IEP, especially some of the details having to do with certain medical records, which is confounding. Mr. Speaker, there's another thing we need to consider, and you've heard some mention of trying to have clarity in the law on a going forward basis. We know there is a growing number of what are called school-based health clinics. Sometimes these school-based health clinics are run by staff of the building or staff of the school district. Other times, those school-based health clinics are run by contracted firms with staffs that are not employees of the school district. Mr. Speaker, in these situations, parents and guardians need to know that they can get access to the medical records that may be a hybrid of school records and medical records, or they may be other sorts of records. It doesn't matter. If the records pertain to services provided to their children, and certainly to medicines administered to their children, those parents have the right to know. This amendment makes that clear. Vote yes on the amendment.
Further remarks? Representative Defoe.
Thank you, Mr. Speaker. Senate Bill 5181 assumes that children need to be protected from their families and their parents by the government. That is wrong. This amendment says, in matters of health care, in matters of medical records, parents and families have the right to protect their children from the overreaches of the government. That happens more than it should. That's why so many people support the Parents' Bill of Rights and oppose what is happening here today. Vote yes.
Further remarks? The good member from the 7th District, Representative Abel.
Thank you, Mr. Speaker. Rising as a proud father of 2 daughters, both of whom are under the age of 12, so this particular amendment feels very personal to me. I do want to address a problem that I know you and I have talked about before, Mr. Speaker, and that is the declining public trust in our schools. And I believe that this amendment could be a modest step toward building and strengthening the public's trust and confidence in our public schools. The Gallup polling organization issues an annual confidence in institutions report, and over the course of the last 5 years, the American people's confidence in our public schools has declined from a percentage of 41%, giving it a great deal or quite a lot of confidence, down to 29%. I don't believe that's coincidence, Mr. Speaker. I believe it overlaps significantly with many of the issues that we're addressing in this bill. I believe this amendment would help strengthen the public's confidence in our public schools, and I ask it be adopted. Thank you, Mr. Speaker.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 1162. All of those in favor say aye. Aye. All of those opposed say nay. No. Division has been called. The Speaker is about to start the roll. Division has been called. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member who wishes to vote voted? Does any member wish to change their vote? The clerk will take the record. I must first lock the device. I have now locked the device. The clerk will take the record.
Mr. Speaker, there are 37 yeas, 47 nays, 2 excused.
The motion is not adopted.
There are further amendments. Amendment 1163. Clerk will read.
On page 3, beginning on line 4 of the striking amendment, internal references accordingly.
Good member from the 25th District, Representative Jacobson, to move adoption of the amendment.
Thank you, Mr. Speaker. I move Amendment 1163.
It has been moved and seconded that Amendment 1163 be adopted. Remarks, Representative Jacobson.
Thank you, Mr. Speaker. This amendment really asks for a small thing. For children under 12, if they are going to be getting medical services at school, and remember we do have some of those health clinics and things, that the parents would just receive prior notification if they're going to be receiving medical services at school or if they are receiving some sort of medication that's going to cost the parents money on their insurance. So this is a simple thing. I wish it went further. I wish it went further. And I wish that parents would be required to authorize this. Thinking about 12-year-olds, Mr. Speaker, I have two 11-year-old granddaughters who are my oldest grandchildren. They're just learning to cook scrambled eggs and be safe in the kitchen. As of yesterday, I could still sprint faster than them in a tag game, and I can tell you that's not very fast yet, and they will be faster. So these are young kids just finding out about the world. Their parents don't let them, use the internet or any such thing. They're 11 years old. They're under 12. These are the students that we're talking about, and at least let's give the parents the prior notification if medicine or services are going to be offered. Thank you, Mr. Speaker.
Further remarks? The good member from the 41st District, Representative Tai.
Thank you, Mr. Speaker, asking you to join me in voting no on this amendment. First and foremost, the most important part of the reason why we vote no on this amendment is because what being asked is already covered under current laws. I want to share with you two little stories about my own children. Even though they are now graduated from college as a proud mom, I would like to share with you one of the event that happening to my son when he was in elementary school. I received a phone call from a nurse at their school asking me to come to the school specifically because he experiencing this stomach ache. And before giving any other medication, which if you have visited any local elementary school and really walk into the nursing's office and checking both the refrigerators and the medical closet, it's definitely significantly less than the medical closet in my home. They are not allow any other medications that are available for these youngsters beside Band-Aid and ice pack. So when I arrived to the school and recognizing that my son have significant stomach ache, I was the only one who would allow to take him out of school and took him to the emergency room. At that point in time, after a while, he was diagnosed with stomach migraine. The experience he received was instead of having a headache, he was having a stomach ache, and which was related to a migraine condition. So these are some of the medical situations that these young people experiencing, and my family was very appreciative of the nurse who make that phone call to us so that we can take care of our young members of our family. And I believe that is how our school follow the current laws. Because of that, asking for your no vote on this amendment.
Further remarks, the good member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker. If children are receiving medical treatment, parents should be notified. I've said that a couple of times over my handful of weeks here on the floor. If they're not happening, it's not an issue. But even something as small as a stomach ache when a child comes in can be a sign of something far worse. And sometimes it should have follow-on care. And a parent being notified that these are going on at school, maybe something's happened at home, maybe there's a correlation, and now this child needs to go get more screening done, more testing done. All that's being asked for with this amendment is that if medical treatment is being given to a child, if the child is going and seeing the school nurse, that the parent is notified, that the parent is aware of the situation. This is really a safety issue, because there could be all kinds of things that seem very, very benign, but are actually a symptom of something much worse. Something as small as a headache could be a slow brain bleed. There are things that are potentially life-threatening, potentially a cluster of symptoms that, when added with the things happening at home, could help paint a bigger picture for a physician in an appropriate setting. All that I'm asking for today, all I would like you to support with me, is that if a child is receiving any sort of medical treatment in the schools, the parent is aware. Please vote yes.
Further remarks? The good member from the 14th District, Representative Manjarres.
Thank you, Mr. Speaker. So I heard on this floor that this is already happening, that it's already enshrined in the bill, or what's happening actually at our schools. If that is true, I think we passed lots of bills off this floor that put teeth more. We've put it into legislation. What's already happening. So if that is true, there should be no reason not to vote for this amendment and allow this to be put into the bill. Thank you.
Further remarks? The good member from the 25th District, Representative Jacobson.
Thank you, Mr. Speaker. Just to bring us back in a little bit, this is for children 12 and under, children who are still in elementary school, and emergencies are also exempted. And I also wanted to point out, and as I often do when I'm speaking, I forgot to say it in my speech. I also wanted to point out, Mr. Speaker, that this is an issue that is worthy of our time. It is worthy of discussion. It is worthy of amendments. We're talking about parents' rights to understand what's going on in their children's lives. So, Mr. Speaker, I urge us to be thoughtful and sober about whether or not we take these amendments and whether or not we pass this bill. Thank you.
Further remarks? The good member from the 6th District, Representative Graham.
Thank you, Mr. Speaker. I am urging a yes on this amendment. Again, Mr. Speaker, things have definitely changed since I was in our public schools and my children were. As a parent, when something was going on with one of my children, I was aware of it. As the parent, what's concerning to me right now is things that have changed from then to now. We have a lot of children that are now dying because they're coming in contact with things that they shouldn't. And that's very sad. Mr. Speaker, what happens if a child is at the school of this age and they come in contact with something they don't necessarily know that it might not be something good for them? Because we have some bad drugs now that are coming in the form of candy. Twizzlers, Skittles. I've had a emergency room doctor show me pictures of it, and it's frightening to see that. So this is important. We need to set the precedent that if our children are going to go speak to somebody that is a medical professional, the parents should know. If they don't know and something happens, how are they supposed to be able to follow up? How are they supposed to be able to talk to their children about what they should be looking for or shouldn't be looking for that could actually save their lives? In the interest, in this day and age, of preventing a child from getting into something that they didn't have to deal with in the past. This is important, Mr. Speaker. Please support this amendment.
Further remarks? The member from the 44th District, Representative Donahue.
Thank you, Mr. Speaker. I wanted to note a couple of things here. One is that in order for kids to be able to receive medication in school, parents have to actually provide that authorization. It comes from us. In situations where there are other ways to access medical care, perhaps with a on-location clinic, it's not going through the school. It's not the school. So in order for schools to be able to provide contact to parents when they're receiving anything from like an on-site clinic, it actually has to come from the medical clinic to the parents, because otherwise it's a HIPAA violation. It's one thing to keep in mind. Now, even when kids have situations where they are able to self-administer medication with life-threatening issues, they still require permission from the parents and from their doctor in order to be able to have that medication on them. I'm urging a no on this amendment because it's actually trying to fix an issue that isn't there. Schools do not provide medical care. And when kids are going to the nurse, parents are getting calls. It's consistent, and it's a good idea for parents to be notified, but the system isn't already in place for that to happen. And when we start putting the same thing in multiple places, it gets very difficult to be able to track it and make sure that we're fixing things in the future. So please vote no.
Further remarks. The member from the 8th District, Representative Barnard.
Thank you, Mr. Speaker. I can only, again, speak to my personal experience, but at the beginning of the school year, parents are given, put in their kids' backpacks, all of these papers that we need to sign, and they come from individual teachers. So you can imagine how many things that I have to sign at the beginning of the year. But one of those papers that I have to sign is permission to give medications through the school nurse, such as Tylenol or ibuprofen. Those are that parents get to choose at the beginning of the year, and I sent in that form. I signed my name to it. It was okay. My child was administered those medicines. I'm just asking for the right to know when and under what circumstance that medication was given to my son. Please vote yes. Thanks.
Further remarks. The member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker. So a couple of things real quick. First, school-based health centers are contracted with the schools. Schools are still responsible for what happens. HIPAA violations, that's federal law. Nothing in this amendment or other amendments that you and I have heard are going to go beyond the scope of federal law. This is a good amendment that will ensure that if these things are happening in the schools, parents are notified. I can speak from my experience. Sometimes I do receive papers to sign so that a student can take something in schools that goes in through that process. But I've also heard countless stories of when that process is not followed. There is a concern, and this amendment addresses that concern. Thank you.
Further remarks. The member from the 13th District, Representative Ibarra.
Thank you, Mr. Speaker. So another example of how schools work and don't work. I'm very proud of where I live in my school district, but I had an incident that happened to my daughter. She was 6 years old in 1st grade, and her teacher was giving her going to the clinic every once in a while because she wasn't feeling all that well, but we weren't aware of it. Her parents weren't aware because we weren't getting called. She would just go to the clinic, stay for a little bit, and then just, no big deal. The next thing you know, I noticed certain things that were going on. Her grades were she wasn't doing just as well as she used to do. And before you know it, we decided to keep her home. She had a stomach ache. She had a fever. And I asked, we went, after about 3 days, she stayed at home. We went to the clinic in town, and the doctor said, your daughter is a type 1 diabetic. You have to go to Children's Hospital right now, or she could potentially die. Because she had no insulin, her numbers were above 500 on the levels of her sugar in her blood. And what this amendment does for us is give that information from the teacher where she was seeing my daughter, seeing her going to the clinic every once in a while. We weren't getting those phone calls. The only reason we knew it was happening is because my wife at the time was working in the school district and started just talking to one of the teachers and said something about my daughter going to the clinic. It wasn't because the school district was calling us. So I think this particular amendment would have helped that situation a lot farther. My daughter may have not been a type 1 diabetic, according to the doctor. He said if we would have caught it a little bit sooner, then it might have not happened. we might have been able to stop that from happening, but we didn't have that time. And so that's why parents need that type of information. And that's why this is a good amendment, because parents don't always know. I was lucky I had, again, my wife at the time, having that, being in the schools and knowing who to talk to. And so I think this amendment is going to make really good information. Afterwards, she got her IEP, she got her 504, we got it all in place. The school district did what it's supposed to do, and we kept on top of them every minute of the day, but it was because I had my ex-wife being in the school districts to keep track of what was going on, but it took somebody in the school districts. I wasn't in there. And so with that, it just seemed to me that most parents don't have that person working in school districts to get the information they require for their kids under 12. Please vote yes.
Further remarks. The good member from the 49th District, Representative Stonier.
Thank you, Mr. Speaker. Asking you to vote no on this amendment. Not too long ago, I was working on trying to get a school-based health center started up in my school district. In leading up to that work, I did visit the school-based health center that is operating quite successfully in Quincy. And it is from that visit that I learned that the contracts between school districts and the healthcare providers that operate the centers are clearly delineated between the work that one does and the work that another does. It wasn't very long ago on this floor when I heard another one of the members of my caucus share that when she took her son to the school-based health center, there was a very clear sign about leaving the school environment and going to the healthcare environment. That is very clear. Disrupting that clarity with this amendment is not a good idea. It's clear in the law, and in cases where it's not being followed, there are other ways to take action on that. Please vote no on this amendment to keep that clear line. One other thing I learned when working on school-based health centers is that the school districts who had brought up some concerns about liability were a constant barrier of questions when I was working on this. So I invited them to the table, and the school district risk assessment folks heard the conversation, got a sense of the contracts, and were no longer concerned about a liability. These are all fair concerns. But they've been put to rest. Please vote no on the amendment.
Further remarks. The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Well, these personal anecdotes are lovely, but let's focus on the actual public policy. Mr. Speaker, this amendment is important, and you should vote yes for it, because there is not a clear mandate currently for schools to report everything they should report to the parents. What the initiative cleared up was where the burden of notification lies. We're talking about personal stories and losing the thread of what's actually happening. Some passive approach to administering medical services to children and letting the parents ask if they know to ask is bad public policy. What the initiative that the underlying bill seeks to gut did was it said plainly and with the clarity that we all seek that burden, that duty of notification lay with the institution to notify the parents. And we can play games with who, what institution it is, which sign is up saying you're in it, well, whatever. The institution has to notify the parents. And we've missed one element of this amendment, Mr. Speaker, in our discussion of it. It's particularly important that the institution notify the parent or guardian if the parent or guardian is financially responsible for the services being provided to the child. Right now, if we allow the underlying bill to gut the Parents' Bill of Rights, there's no notification to the parent or guardian in every matter that may affect their financial circumstances, what they are legally and financially obligated to pay for. This is ridiculously bad public policy, Mr. Speaker. We need to, when a parent or guardian is going to be on the hook financially for services provided to their child, to administer those services without notifying the one who's going to be responsible is irresponsible public policy. The amendment clears this up. In the interest of every parent who pays health insurance premiums every month, vote yes. Protect them.
Further remarks. The member from the 13th District, Representative Ibarra, and the member has 18 seconds remaining.
Thank you, Mr. Speaker. Being a school board member in Quincy who set up the clinic in Quincy, that clinic is in the high school, for high school kids, not for elementary. Also, every kid that uses that clinic, their parents has to sign a form that says the kid can use the clinic.
The member's time has expired. The member from the 15th District, Representative Corey.
Thank you, Mr. Speaker. Urging a yes on this important amendment. Parents around this state, when they drop their kids off at school, don't think to themselves, I'm dropping my kids off at school and maybe a medical center or other health care center. They're dropping their kids off at school, and they should be notified in any instance when anything happens on school grounds during the school day, on school time, about what happens to their kids. There's no indivisible dividing line when you walk over a thing when there's a notice that says you're now in healthcare land. As a parent, when I drop my kids off at school, they're at school, and that's why parents need this notification. Please vote yes.
Further remarks. The member from the 26th District, Representative Caldeer.
Thank you, Mr. Speaker. So I've just been listening to the debate on this particular amendment, and I am so confused because first I heard that we didn't need the amendment because it's already being done, and then I heard that actually these school-based centers or the school-based healthcare centers, that they're completely separate. But if they're completely separate, why wouldn't the parent even be notified that the child will be going there? So the thing is that if you and I do not listen to the people, I don't know if you've seen what the enrollments rates are for students in the public school, but this amendment, whether or not it's accepted, that will determine whether or not more parents take their children out. Because at the end of the day, I don't care where you came from, what area you're from, across the state, what your background is. Mamas want to protect their babies. And at the end of the day, if they're dropping their children off at school and that they find out later on that that kid is getting some sort of mental health counseling or some sort of procedure or medication that they did not approve of, I'm going to tell you the first thing they're going to do is they're going to take their kid out and they're going to rethink either A, maybe I should go to another state, or B, maybe I should homeschool my child. And if that's what you want, then go ahead and pass this amendment. And when enrollments drop, remember this, because I'm just going to say I told you so. I urge adoption of the amendment.
Further remarks. Seeing none, the question before the House is adoption of Amendment 1163. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. Division has been called. The Speaker is about to start the roll call machine. Speaker has started the roll call machine. Of all those that wish to vote, voted. Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Will the clerk please take the record?
Mr. Speaker, there are 39 yeas, 51 nays, 2 excused.
The amendment is not adopted. There are further amendments. Amendment 1164. Clerk will read.
On page 3, line 18 of the striking
Last line.
amendment, internal references accordingly.
The member from the 2nd District, Representative Marshall, to move adoption of the amendment.
Thank you, Mr. Speaker. I move Amendment 1164 for adoption.
It has been moved and seconded that Amendment 1164 be adopted. Remarks. Representative Marshall.
Thank you, Mr. Speaker. You and I have heard a lot of discussion right now about notification to parents. What this amendment would do is clarify and make statutory a lot of the concerns that you and I have heard from constituents and was part of the underlying law that is going to be changed by this bill. This amendment would state that any medical, mental health, or behavioral health services that are provided by a school are sent out to parents in a form of notification. This would ensure that parents and schools are on the same page and are aware of what services are actually being provided on school property or property owned by the schools. So that when a parent sends their child to the school, they are well aware that certain things may occur. Even if it's not happening in person on campus, if there's arrangements for telemedicine services or other sorts of counseling, even if it's with contracted persons or entities, if it's happening on school property, the parents are aware that it is something that may go on in just the form of a notification. I think this is a great clarifying amendment, and I urge you support its adoption.
Further remarks? The member from the 37th District, Representative Santos.
Thank you, Mr. Speaker. Asking that you accept this amendment. I think the gentleman makes good points. Although I will just make a note, Mr. Speaker, if you are concerned about the type of medical services that your minor children might be receiving with or without your consent, there are many documents that you can find. In fact, if you don't mind, Mr. Speaker, I'd like to cite the WashingtonLawHelp.org.
Please proceed.
So where you would learn, Mr. Speaker, that for a student experiencing emergency medical needs, a minor can consent to their care if no adult is readily available. You would also note that if a student is homeless, they have rights under the McKinty-Vento law, a federal law. You would also want to know that under RCW 9.02100 sub 1, your minor child could consent to receiving birth control services. In other words, Mr. Speaker, the information is already existing, free and available for you to find if you just Google, but I'll give you WashingtonLawHelp.org as a place to begin. In the meantime, we will accept this amendment.
Further remarks? Seeing none, the question before the House is adoption of Amendment 1164. All those in favor say aye. Aye. All those opposed say nay. The amendment is adopted. There are further amendments. Amendment 1155. Clerk will read. Bless you.
On page 3, beginning on line 35 of the striking amendment, after 2,
Last line.
Line 4.
The member from the 25th District, Representative Jacobson, to move adoption of the amendment.
Thank you, Mr. Speaker. I move Amendment 1155.
It has been moved and seconded that Amendment 1155 be adopted. Remarks. Representative Jacobson.
Thank you, Mr. Speaker. This amendment just restores provisions granting parents and guardians the right to know if their minor child has been taken away at school time to another location, including if they're taken away to stay at a youth shelter or a host home. I think that in these situations where a child is in a difficult situation, they need their parents. So, Mr. Speaker, permission to read one of our constituent emails?
Please proceed.
Thank you. I work in a pediatrics office. Recently, I received a phone call from a frantic mother who had just sent her child to school, and that child was now missing. Her 13-year-old daughter had been dropped off at school on Thursday morning, just like every morning. Somewhere along the line, the principal and the nurse held a Zoom video appointment with our pediatric provider due to the 13-year-old feeling depressed. The school and the pediatrician decided to help keep the child safe, and then she was taken to Sacred Heart for inpatient services. This child never came home that night. Sacred Heart agreed to keep the child for a 72-hour hold. It was now a Monday morning. This mother had spent all weekend trying to locate her 13-year-old, only knowing that she had sent her child to school, and now nobody could tell her anything, including me. This child was eventually released from the 72-hour hold, but she stopped receiving follow-up care because she had no further means to receive it. She didn't have an adult to help her make her appointments, help get or manage medications and side effects, or monitor her safety at home. How are parents supposed to keep their children safe when they are unaware that their children are suicidal or depressed? How do they know to look for carpenter's knives, hide sharp objects, and take special precautions with medications like Tylenol if parents are left out of the equation? Our teachers and public schools are not equipped to keep children safe with their student-to-teacher ratios. This child was able to access brief care, but not follow-up care. The school could not keep this child safe from suicide at home or on the weekends. And then this goes on to talk about the particular bill that this person was mentioning. So the point is, if kids are taken away somewhere, parents have to know, because parents are who the emotional support of the child is. Thank you.
Further remarks? The good member from the 43rd District, Representative Macri.
Thank you, Mr. Speaker. Please vote no on this amendment. Mr. Speaker, as you know, in 2023, this legislature established provisions that were put into law to help keep students safe and, frankly, alive as we work towards family reunification. And this amendment would repeal some of those provisions. Mr. Speaker, as many as 40% of our homeless youth identify as LGBTQ, and in Washington State, we have the highest proportion of any state of homeless youth who identify as trans or gender nonconforming. We have an obligation to keep our children safe. For that reason, I ask you to vote no on this amendment.
Further remarks? The good member from the 35th District, Representative Couture.
Thank you, Mr. Speaker. I just wanted to clarify for you that this amendment does not alter the RCW of the bill, Senate Bill 5599, that was passed in 2023. All this amendment does is say that if your child is removed from public school grounds to go to and it adds in to the underlying bill, a youth shelter or host home, that the parent should be notified. Now, Mr. Speaker, I know we're both fathers. Could you imagine that your child never came home and somebody somewhere at the school or possibly a youth shelter, possibly Department of Children, Youth, and Families, knew that your child went to a host home or a youth shelter without your knowledge, and they didn't even have to tell you? I know, probably like you, that I would be sick to my stomach if one of my 4 kids just didn't show up back home and the government knew about it. That's wrong, Mr. Speaker. All this amendment does is say that if your child is sent off of school grounds to a youth shelter or host home, that the parent is notified. We want to know that our kids are actually alive and not kidnapped or something terrible that has happened to them, not a 72-hour hold like we've heard in the story just a little bit ago. But I just wanted to make it clear that this amendment does not change the RCW that was put in place by Senate Bill 5599 in 2023. All it says is that if you remove a child, which is already a part of the underlying bill, from public school grounds, and it includes, including to a youth shelter or host home, that parents should be notified. I think that's common sense, and I think it builds trust with the public. Mr. Speaker, please vote yes.
Further remarks, the good member from the 6th District, Representative Graham.
Thank you, Mr. Speaker. I am rising in support of this amendment. In my district, I've had people that have reached out to me from NAMI who have had loved ones that struggle with mental health issues. And one of the things that was happening during that time is when they don't know what happens to their loved one, what do? One of the things they're going to do is they're going to call the police. And we already have an issue right now with being the dead last in the nation for police officers per capita to be able to manage these types of calls. Mr. Speaker, why would we make that harder? Why? There's no way on earth that a parent is not going to worry about a missing child. Why would we add that kind of worry? Mr. Speaker, and it's not just the parents. It's also maybe the siblings. I know what it's like to have a sibling that you don't know where they are. And as a child at that point in time, I'm going to tell you, Mr. Speaker, that was very traumatizing, extremely traumatizing for those children. We have the opportunity to not cause problems, extra problems for our police. We have an opportunity to relieve some of the stress on parents and siblings and grandparents and people that care about these children to simply say they are in a safe place so that these parents and loved ones are not having to worry. For that reason, for common sense, please support this amendment.
Further remarks, the good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Good amendment. Vote yes. Mr. Speaker, when I was drafting Initiative 2081 and speaking with parents all around the state about what their concerns were about public policy that cut them out of their own kids' lives, this matter of children being taken off school campus and parents not being notified was one of the main concerns. And yes, one of the main breaches of trust between families and our schools in this state. Now, the initiative and the law that's in place now does a lot to bridge that breach, to cure it, to restore the trust that families have toward our schools. And that's essential, as you've heard references to trying to stop the exodus of families out of our public school system. But Mr. Speaker, there's an issue here that's bigger even than the limits of the focus of the language of the amendment and the problems in the underlying bill that it repairs. This matter of taking kids off school grounds, off campus, is a matter of interest isn't the word, urgent concern for parents and guardians around this state. And some of their concerns have not to do with taking a child off for medical services or therapy counseling or to stay at a host home or whatever. There have been horror stories told of students being taken off campus, in some cases by school staff, and abused. Now, this amendment can't address all of those circumstances, but it is a bright line for parents and guardians and grandparents and families to see in our law. That if the child goes off campus, there is a duty for the school to notify the parents. I think this will remedy a growing problem. And I think it will restore trust between families and schools. This is an important amendment. Vote yes for trust.
Further remarks, the good member from the 21st District, Representative Ortiz-Suff.
Thank you, Mr. Speaker. Mr. Speaker, I don't know what to say to some of the remarks I'm hearing because as I travel the state,
The Speaker will please remind members to please speak to the policy at hand. Please proceed.
Speaker. Mr. Speaker, when I talk to schools around the state, and in my own experience as 20-some years as an educator, we do not take our students anywhere without parent permission. I have sat with students in my office crying because their parents didn't sign the field trip form and they're not allowed to get on the bus. We don't take them anywhere without parent permission. However, law enforcement can come in and pick up a child, and our hands are tied. The Department of Children and Family Services can come in and pick up a child, and our hands are tied. But we check. If we are excusing a child and letting them out of a building, we have to make sure that they have permission from a parent to leave that building. We do not give permission. That doesn't mean to say that students may not leave and we don't know in our high school area. But if we know, parents know. We are not hiding from parents that we are removing kids from school. That is not something we do, not something we want to do. However, as I said, under emergency situations, and I can't legislate for the 90% of the time. I have to legislate for the 10% of the time where I deal as a school counselor with emergencies and situations that we have to make sure on this floor that everyone is protected. Thank you, Mr. Speaker.
Further remarks, the good member from the 15th District, Representative Corey.
Yeah, thank you, Mr. Speaker. Rising to support this good amendment. If, Mr. Speaker, law enforcement, DSHS, whoever else were to come and remove a student from school, I would expect, I would demand, and I think every parent in this state would say the school should be required to notify them of what happened. And this amendment does that. And maybe this is a small minority of what could possibly happen. But to that one parent that this happens to, that's no longer a small minority. That is the problem. This amendment helps address that. And Mr. Speaker, unfortunately, due to some laws we have passed in this state, we are adding and creating situations where schools can and will remove kids. What this amendment says in this particular scenario is that parents must be notified. And I would like to think, Mr. Speaker, you and I may have differing political priors, but I would like to think that we would believe this whether it was my side in favor of it or your side in favor of it. No matter the situation, no matter if it was a different state who had a different set of values that they thought they would enforce on those students outside of the parents' control. I would have a problem with that. I have a problem with it in this case, and I think this amendment helps address that, and I would hope you'd vote yes with me, Mr. Speaker.
Further remarks? Seeing none, the question before the House is adoption of Amendment 1155. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment 1153. Clerk will read.
On page 4, line 14 of the striking
Last
amendment,
line.
Internal references accordingly.
Good member from the 6th District, Representative Oles, to move adoption of the amendment.
Thank you, Mr. Speaker. I move Amendment 1153.
It has been moved and seconded that Amendment 1153 be adopted. Remarks. Representative Oles.
Yes, thank you, Mr. Speaker. This amendment intent is to preserve and strengthen women and girls sports in Washington State. The science is settled. There are significant differences between males and females, and these differences manifest themselves as early as like 7 or 8 years old, where men have more muscle mass. Men are taller, men are stronger, men are faster, and that's just a settled biological scientific fact. In fact, by the age of 18, men are 5 to 6 inches taller, 30 to 40 pounds heavier, and have 10 to 15% more muscle mass. In sports, I don't know if you played sports, I played some sports, that's a very significant difference. And in fact, if you look at male sports and women's sports, such as wrestling, the martial arts, boxing, they put weight classifications. Professional boxing, for example, or college wrestling, or high school wrestling, where you have these trained athletes, men fighting each other, young athletes wrestling each other, boxing each other. They put these weight classifications in, not to protect the smaller athlete, but or not to protect the larger athlete, but to protect the smaller athlete. And that's just a common sense, fact-based approach. Also, when we look at the United States military, they have two separate standards, one for male, one for female, to acknowledge the fact that men are stronger and faster, have more muscle mass, are taller. So in the Army and all the military branches, they have two separate tests. And so I think when we look at this, it is to protect young girls, young ladies, and women in sports in the state of Washington. And same with nationally, the national trend is moving away from that. So I think by allowing it in Washington state, in addition to the number of lawsuits that are already emerging from our state and other states on this very issue, it also precludes a lot of young ladies and women from advancing to the next level. Maybe they lose out on a scholarship option. Maybe they lose out on national recognition. Maybe they lose out on international opportunity. So I think hopefully you can join me in a yes vote to preserving women's and young ladies' sports in Washington state. Thank you.
Further remarks, the member from the 29th District, Representative Mena.
Thank you, Mr. Speaker. This amendment relies on two erroneous premises. The first, that trans girls are not girls. Not true. And the second, that boys are inherently better athletes than girls. Not true. Mr. Speaker, I have 3 young and healthy brothers, and if I challenged them to a race or a game of hoops, you would do well to place your bets on me and win some easy money. I grew up playing organized sports: basketball, volleyball, softball, track, cross country. I wasn't always the tallest. I didn't have my growth spurt till later on. I wasn't always the fastest. I wasn't always the strongest. We were all built different. The kids that outperformed me were motivation, pushing me to work harder, to be better. Sports helped me develop leadership skills, to build confidence, and they taught me valuable life lessons: how to win and to lose with grace, how to work hard toward a goal, and how to remain committed to myself and a team. Every girl deserves the opportunity to show her stuff on the field, to find out what she's made of, to shine. But this amendment seeks to take this opportunity away from some girls. Gender identity and gender expression are protected classes under Washington state law, which means that schools cannot discriminate on these bases. Furthermore, this narrow and binary language in this amendment puts kids into a box, the kind of box that prevents boys from seeking careers in nursing, education, or caregiving, and the kind of box that says girls need an extra layer of parenting when playing sports, but boys don't. Please vote no.
Further remarks, the member from the 19th District, Representative McIntyre.
Thank you, Mr. Speaker. Trans women are men. I cannot believe what I'm hearing. I must be having a fever dream right now. I'm going to wake up. I can't even believe it. The science is as settled as any science can be. It is absolutely settled. There are biological differences. And when it comes to sport, that includes speed and strength. The bell curve of males, of men, is pushed far to the right, that of females. It is true that if you look at the two bell curves, there are some females which are stronger than males. In fact, there's quite a few. But when you're dealing with sports, you're not dealing with averages from a population. You're dealing with those who have a desire to play the sport and are working towards it. And in that, the bell curves get even more divided. There is no question, Mr. Speaker, that I can't even believe it's been said that there's no biological difference.
The member will please keep remarks to the policy and at hand. Please proceed.
I can't believe the policy then. The policy is horrible. The amendment is absolutely necessary. Mr. Speaker, we have to protect our daughters and our nieces or granddaughters in the sports that are for them. That's why we did this decades ago. That's why we made these separate categories, is because we said, if we're going to have it like a free market, and you know I'm a free market guy, and say everyone should be able to compete, the girls will never be able to win. Is that what we want for our daughters, Mr. Speaker? To never be able to win a medal or a trophy ever again? The women's national soccer team played 14-year-old boys in soccer and were annihilated by 14-year-old boys. How did it happen, Mr. Speaker? Because there's a difference. We have to protect our young women, our daughters and our nieces and our granddaughters in their sport. Because the science is settled. It's beyond debate. And again, it's 2025, Mr. Speaker. How are we, it's not 1850. What are we, I can't believe it. So anyway, before I get gavelled again, you need to vote yes on this because you believe in science and I believe in science.
Further remarks, the member from the 6th District, Representative Graham.
Thank you, Mr. Speaker. This is an absolute wonderful amendment. As a biological female, I am standing up for the rights of biological girls and women. Mr. Speaker, biological girls and women are being beaten and bruised. They are having things taken from them, opportunities that they've worked for their entire lives. When in a situation we see males who are competing in sports and just on a whim, because they aren't able to handle being on a male's team, decide just like that to say that they're female. And now they're competing against females. That's wrong, Mr. Speaker. There were hard-fought battles for women to be able to have rights for our own spaces. It seems awfully funny to me that when you look at what it is that's happening, you don't see biological women who are saying that they're men who are dominating male sports. That's not happening. We're not seeing biological females saying that they're men who are taking away opportunities from male athletes. If that's happening, I would love to see the proof of it. But the bottom line is it's not. And it's long past time that we start taking a look at the damage that's being done. There is video proof of females that are being brutalized on baseball courts, on different other sports. It's unbelievable to me that we're in a position right now that we are seriously putting somebody that self-identifies. We're talking about a situation where somebody can be male 1 minute and then decide that they're female the next. And now all of a sudden they're qualified to invade our biological female spaces, take over our sports, and totally, basically eliminate us. That's wrong. And for that reason, Mr. Speaker, vote yes on this amendment.
Further remarks, the member from the 28th District, Representative Levitt.
Thank you, Mr. Speaker. Please excuse Representative Simmons.
The member is excused. Further remarks, the member from the 11th District, Representative Berquist.
Thank you, Speaker Timmons. I've got a few perspectives here. One as a teacher, also as a coach, and as a father of what she would consider a very awesome 11-year-old daughter. I usually agree with her. And what I like to do when we're faced with some of these decisions is really talk to the bosses, our bosses, about their perspective on these issues. I think a couple weeks ago I had a really good debate with 50 fourth graders around whether or not we should require computer science in order to graduate. And it impacts them, getting their opinion. We had a heated discussion in our committee about that bill last year. It was nothing compared to these fourth graders and the opinions that they brought to the table. So when we had an amendment very similar to this in committee, I actually talked to my 11-year-old daughter and asked her what she thought. And her first reaction was, why would we want to leave out other students? Shouldn't all students be able to be included? And Speaker Timmons, that makes sense. It really does feel like if we were to take an amendment like this, I feel like this would only serve to codify exclusions that would isolate and marginalize her fellow students, her fellow classmates. And I think we really need to focus on what's best for our students, making sure that they're in a safe and respectful learning environment, and we should turn down this amendment. Please vote no.
Further remarks, the member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker. So I'm going to talk a little bit about the biology that we're hearing about. I mean, this is where I've spent my entire professional life. You know, one of the things that we hear about, well, first off, you and I, we've heard lots of discussion about spaces and about injury concerns. You know, my profession has been in sports medicine. In that, I deal with athletes. In sports medicine, I've also dealt with collegiate and pro athletes. There is one thing that happens to all of them. If their testosterone levels are too high, they are suspended. They are disqualified. They are not allowed to participate. We've even seen professional baseball have giant scandals about performance-enhancing drugs, and testosterone's on that list. In our teenagers, a teenage boy's natural testosterone level is somewhere between 800 and 1,200 nanograms per deciliter. I think I'm getting that exactly correct. In an adult male, the low end of normal is 300 to 400. In a teenage female, we're at 25 to 75. We are allowing people with raging hormones, testosterone levels that are far exceeding what an adult male walking around has going through their bloodstream. We're allowing them to compete in sports with females who do not have even nearly that level of testosterone. That's a performance-enhancing drug. We don't allow it in our professional athletes. We sanction them. This should not be happening in our schools. This amendment is all about making sure things are fair, an even playing field, no unfair advantages, and it's for safety. We can make, you and I, we've heard the arguments for both sides about participation, but Title IX is very, very, very clear that we need to have separate sports available, and we need to have leagues. They're based on ages. In some sports, it's on weight classes. But the gender classification is important as well, because it can be dangerous if one person has this unfair advantage and can cause actual harm to others. I urge your adoption.
Further remarks, the member from the 6th District, Representative Oles.
Thank you, Mr. Speaker. I know I don't
The member has 28 seconds remaining.
Yes, thank you. Just want to hit on a couple issues. First of all, this amendment does not exclude anybody. No more than weight classes in wrestling excludes people. So it is meant to be inclusive, but it's meant to protect those safe spaces and those sports. So we spent decades creating women's sports. What this does is it secures those women. It gives them an opportunity to compete. I watched disqualification where people, they refuse to compete. They're left out.
The member's time has expired. Further remarks, the member from the 14th District, Representative Manjares.
Thank you, Mr. Speaker. It's my belief that we're having this conversation. It's a direct attack on women and on girls.
Please do not impugn the motives of members' arguments and speak to the policy at hand. Please continue.
We need to protect, thank you, Mr. Speaker. We need to protect the rights of biological girls and women. Men and women are different. I believe men and women are different. I like the differences. There's a strength difference from the very minute that they are born. We fought very hard for Title IX. Girls' sports. Oh my gosh, that was an entire victory for women. Girls' sports. The right to vote. Women's spaces. And as a woman, I am so proud of that. We are not being unfair to anybody by adopting this amendment. We need to protect our girls and our women. Please adopt this amendment.
Further remarks. The good member from the 37th District, Representative Santos.
Well, thank you, Mr. Speaker. I, too, am very proud that we have Title IX. I'm proud that the first woman of color in Congress was the sponsor of Title IX. But that was adopted 50 years ago. This is a new generation. And Mr. Speaker, I will tell you, you know I have 27 now great-grandchildren, most of whom are girls. And I will tell you, my grandchildren, my granddaughters will assert they don't need to be protected by men. They can take care of themselves. I also just want to say why I am asking you, Mr. Speaker, to vote against this amendment is because as I was listening to some of the anecdotes, I was thinking about two great-granddaughters in particular, two 16-year-olds, who both play football, as I learned. One is about my size and one is very, very petite. And one of the things I will tell you that I was surprised to learn is they play football against boys. And they love it for many of the reasons that you heard from the good lady from the 29th. It makes them excel. It makes them hungry to perfect their game. But, Mr. Speaker, I also heard that we needed to segregate by gender because of fears that trans athletes have some sort of advantages because they're trans. Mr. Speaker, I would argue if that's the logic, then what we ought to be doing is matching athletes based on size, based on skill, and based on their ferocity. Because my smaller granddaughter will beat the pants off of any man, any boy that she meets on the field. Mr. Speaker, please do not accept this amendment.
Further remarks, the member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Male athletes don't have advantages because they are trans. They have advantages because they're males. Mr. Speaker, this is a good amendment. Please vote yes. It is a novel theory that a new generation will somehow negate the intent and effects of Title IX of the Civil Rights Act. Title IX was a hard-earned victory for girls in sports at all levels. And to undermine that with a current fashion toward allowing men to play in women's sports is an affront not just to science, it's an affront to common sense. This amendment clears up the confusion. It doesn't exclude anyone from anything, but it does protect a thing worth protecting, which is the ability of girls at the elementary and high school levels to participate in sports in a way that does allow them to excel, and does allow them to become self-actualized, and does allow them to have the physical confidence that sports at its best can give a person. Protect girls' sports and protect the girls playing it. Vote yes on this amendment.
Further remarks, the good member from the 26th District, Representative Caldeer.
Thank you, Mr. Speaker. So I'm so confused because one of the things that we have seen is that there has not been any women who identify as men participating in men's sports. There hasn't been that issue. It's only been the reverse in our state. In fact, it's been like that throughout the whole country. And I don't know if you like hearing these debates so much that there's a very good chance we're going to wind up going into special session because...
The member will please speak to the policy before the body. Please proceed.
Oh, thank you, Mr. Speaker. I am absolutely speaking to the policy because...
Further remarks. The member from the 4th District, Representative Chase.
Thank you, Mr. Speaker. Xena the Warrior Princess was not a historical documentary. It was Hollywood. And, I think as far as men competing with women on a level playing field, Andy Kaufman proved that fallacy decades ago. But it's fun to play Jack and Jill football or soccer or softball, and that's a good place to, it's a different level of competition, though. Actually, it's a good place to meet other members of the opposite sex, but you're not trying to brutalize them, I think you want to meet other people and have fun. And, you don't want to, ask out someone, I'm sorry I broke your ribs, but are you doing anything Saturday night? So I think what we need to do is we need to be ladies and gentlemen. When I was younger, I was interested in boxing. My problem was I wasn't strong, I wasn't fast, I didn't have a lot of endurance, and I didn't like people hitting me. So I looked for other things to do. So I think we need to be what we were meant for, and I urge a no on this bill. Thank you.
Further remarks. The member from the 9th District, Representative Dye.
Thank you, Mr. Speaker. Our family was fortunate to have a great cross-country team in our kids' school. And my daughter had the privilege of training with Olympic athlete Paul Ryan. And it was because she was a little faster than the girls in her class and some of the boys. But she ran well side by side while he was training. And but when she went to compete, she competed in the girls' races because she had trained well and she was talented, and she would not have been able to won anything, even though she was best of class for her local team. And it gave her a great deal more confidence in herself, and it was really essential in her growing up. We talk a lot about equity on this floor and in our bills. We write a lot about equity, and this is an equity issue. It's an equity that says that even some of the most talented young ladies, they should have the equity of being able to compete with people that are working at the same level and capable of competing with each other. We're not talking about equity when we talk about making our young girls have to compete with young men and boys. They aren't going to have the fairness that they need. It's not equitable at all. And I know that I care a lot about having my kid have opportunity. And I think a lot of us care a lot about our kids, our young men having opportunity and having our young women having opportunity. It doesn't always mean that your kid is going to get the scholarship or make the professional team, but in their category, in their class, to be able to know that they have a fair chance, it gives them hope and a heart. And I'm really grateful that my kid had the privilege of getting to know Paul Ryan so well, and I wish him well in his Olympic career. He does run consistent sub-4-minute miles, and he's a great joy to watch as he competes at the Olympic level. But for my kid, she can always think back on those wonderful times when she had the opportunity to train with a champion, and it made her a better runner. But she competed and won a lot in the girls' division. Thank you.
Further remarks. The good member from the 25th District, Representative Keaton.
Thank you, Mr. Speaker. We're in a budget crisis. We know this. We know our school districts didn't get all the funding we wanted to be able to give them, and they're also making tough decisions. Our risk pool in my district, 10 years, has gone from $600,000 to over $5.6 million. We can't afford lawsuits, and we certainly can't, as a state, afford to risk losing federal funds. Let's take this amendment. Common sense. Let's pass this amendment. Vote yes.
Further remarks. The good member from the 13th District, Representative Ibarra.
Thank you, Mr. Speaker. Just just to let you know, and you probably already know this, I think we've talked about it, I used to be a wrestling coach for little kids, for high school, for junior highs, a little bit of college wrestling, and I've seen kids over the years, thousands and thousands of kids. In the old days, it was just a couple girls that were in those particular programs and stuff, and some of those girls are tough as nails, toughest kids you ever saw. And they did great while they're in the little kids. As they got older and the boys got stronger, they got stronger. But there was a definite difference between a little kid wrestler, boy or girl, to a high school wrestler, woman and man. And you could see the difference as a coach, seeing all these kids. And it wasn't that they were not better or worse. Some of those girls were the best student athletes that I've ever seen. The toughest, meanest kids ever. But at the same time, I also knew that as time went on, boys were getting a little bit stronger than most of the girls, so you only had a couple girls proceeding that way. The state of Washington and across the nation, what's happening now is people saw that. So we wanted women to have their own wrestling program. So now instead of having 1 or 2 girls in the state of Washington, maybe 50 or 60 women on the boys team, there's now women's teams, and there's about 250,000 women wrestlers that are tough as nails, the toughest wrestlers you ever saw. In fact, one of them from my hometown wrestles at Evergreen. She's a world champ. She could take me down in 2 seconds because she's that good. But if at that level, at the world championship level, she cannot even come close to compete with the boys because of the difference in the biology. And that's just experience from a coach that worked with women and with men. There is ways to make it happen for the good, which is if there's a place to put a team or a league in place for both, then let's do that. Because women are just as tough as men, definitely when it comes to competing. Thank you very much.
Further remarks, the member from the 12th District, Representative Burnett.
Thank you, Mr. Speaker. I'm a father of 7, 10 grandkids, 2 on the way. I congratulate the good member from the 37th. That's a blessing. That's a huge thing. I hope that I live long enough and prosperous enough to even come close to that. But what I have seen over the years, my first 5 were boys. And I had my biological daughter, that was our number 6 child. She's a competitor, no doubt. And I've heard the other members talk about this. But when it comes to specific things, she taps out. Now let me go back to, I coached a lot of Little League baseball. That's what I'd played. I tried to play football in high school, went to a small single-A high school. Mr. Speaker, when I was in 8th grade, there was only one person in the class that was shorter than me. It was one female. And as much as I wanted to be aggressive and play football, I grew 4 inches between my 8th and 9th grade year, came in at a whopping 5'4", 104 pounds. And I went out, tried football, wanted to be aggressive and play with the rest of the guys on the team. I got my bell rung because we didn't have a freshman team. We had a JV team and a varsity team, and guess what? We got to all practice on the same field. As much as I wanted to, Mr. Speaker, it wasn't to my advantage, so I pulled back and said, I'm going to play baseball because it really doesn't matter the size of that. You can really apply yourself. Now, coaching Little League, Mr. Speaker, I even coached my niece, who went on to play collegiate level softball. Probably could have played Division II if she chose to, but that's not where her heart was. Her heart was, I want to play for this school. I want to be closer to home. But she was amazing. And she played Little League up to about 12 years old, and there becomes a separation. Now, I've heard a lot of different arguments, a lot of different angles. We've talked about equity, inclusion. We've talked about there's really no difference with the gender, and there shouldn't be anything. But I think the heart of what we're looking at is we're talking about, when I taught Little League, especially at the younger years, it's about what are we teaching them? It's about winning and losing. It's about how do you adapt and respond to the tough times. We're teaching them responsibility. We're teaching them commitment. So, Mr. Speaker, if we're not going to be able to figure something out together, then let's just put it all in one league. And let's let the survival of the fittest, because if that's what it's all about, then let's see how it falls down. Thank you, Mr. Speaker.
Further remarks. The good member from the 25th District, Representative Jacobson.
Thank you, Mr. Speaker. I have 5 daughters. 18th grandbaby is coming. For my 5 daughters, I always wanted them to be able to take care of themselves and be well educated and have great, value themselves highly enough in society so that they weren't taken advantage of. My daughters did athletics. I never did. And they pretty much did gymnastics, and one of them became a D1 gymnast and got a scholarship at Oregon State. And I have to say, I would hate to think that in things like track and field and other sports that we're not allowing these gals to get the opportunity that my daughter, who was a D1 athlete, got. When you look at track and field, Mr. Speaker, for children 8 and younger, even 8 and younger, those hormones are in play. Those records that are held by the boys are higher across all categories than the records held by girls. And you can cite anecdotal examples and specific examples where one gal, can whoop most of the boys. But if you look at averages, men are stronger, they are faster, those hormones have done them a big favor. And so I just hate to think that we are not allowing our gals from going forward to have the same opportunity that my daughter had. These sports, she's content with her body. She's strong and she doesn't have any issues with her body being something that functions super well and can do amazing things. I want all girls to have that. I want my daughters to have that. I want your daughters to have that if you have them. Mr. Speaker, I urge an adoption of this amendment. Thank you.
Further remarks, the member from the 8th District, Representative Connors.
Thank you, Mr. Speaker. Hard topic for a lot of people today. I will say, I don't know if you're aware or not, but on April 4th, which was just 10 days ago, there was a civil rights complaint filed by 2 young ladies, 2 young high school students in Washington State, one from Prosser High School and one from Gonzaga Prep. Those 2 ladies were in a high school track meet for the state championship. And a transgender biological male put one of those young ladies into 4th place. It took away her right on the podium stand. Mr. Speaker, I was born in 1966, outing my age right now. And in 1966, when I was born, things looked very, very different for young girls. Back then, girls weren't necessarily on sports teams. We didn't have equal access to sports and other educational opportunities. In fact, Mr. Speaker, when I was in kindergarten, I wasn't allowed to wear pants to school. I had to wear a dress because that's what was expected of me. In 1972, the same year that I went to kindergarten, Title IX came into effect in the United States. And for the first time in law, the land for girls changed. It changed everything, Mr. Speaker. It opened doors for generations of young girls and young women. In classrooms, in sports fields, and eventually in boardrooms, and in places like this, in chambers of government. As a mother of 3 girls, as a former athlete myself, and now a state representative, I will continue to defend all of the progress that we have made for young women. I cannot and will not personally allow women's rights to be eroded in our state. Please vote yes on this amendment.
Further remarks, Seeing none, the question before the House is adoption of Amendment 1153. A roll call vote has been requested. The Speaker is about to start the roll call machine. The Speaker has started the roll call machine. Has every member voted? Representative Fye, how do you vote? Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Will the clerk please take the record?
Mr. Speaker, there are 38 yeas, 58 nays, 2 excused.
The amendment is not adopted. There are further amendments. Amendment 1168. Clerk will read.
On page 4, line 14 of the striking
Last line.
Internal references accordingly.
Good member from the 35th District, Representative Griffey.
Thank you, Mr. Speaker. I move for adoption, House Amendment 1168.
It has been moved and seconded that Amendment 1168 be adopted. Remarks, Representative Griffey.
Thank you, Mr. Speaker. This amendment is an attempt to fix a real problem that I've experienced in my district in talking to the constituents that I represent. 3 of my school districts have transitioning males showering with females in their sports locker rooms. I contend, and the parents contend, that that is a mistake, Mr. Speaker, and subjects young women who do not want to be exposed to the genitalia of young men in a negative way. Mr. Speaker, the consensus was in the community, we recommended to the school district that we offer a separate shower arrangement for the person who was transitioning, and the school told us they can't do that because the superintendent of public instruction said that he will cut the funding to their schools, and they believe that they're taking the risk-averse posture by forcing our young girls to shower with transitioning males with male genitalia. Mr. Speaker, what this amendment would do was say it would allow our school districts to offer separate shower facilities so our young girls do not have to be subjected to the male genitalia while they're showering, Mr. Speaker, for our girls, for our schools, for our parents who are demanding action. Mr. Speaker, allow our schools to make this positive, enriching choice that will protect both the transitioning male and young females. Mr. Speaker, I urge its adoption.
Further remarks, the good member from the 21st District, Representative Ortiz-Self.
Thank you, Mr. Speaker. I'm going to ask for a no vote. Mr. Speaker, our schools have been very creative without the funding that we can provide them at this time. They've been very creative in trying to individually meet the needs and concerns of all parents, and they do that in a variety of ways. Mr. Speaker, we have students who have disabilities that require also separate accommodations, and the schools work on different time schedules, and they work on meeting their needs as well. To ask every school in our state to build a separate shower is way beyond the means of our state at this time. However, our schools want to reiterate that they are accommodating the needs of our students. We also want to make sure we don't get into litigation by discriminating against anybody and making sure that all students have the right and access that is due them. So with that in mind, Mr. Speaker, I'm going to ask for a no vote.
Further remarks, the good member from the 35th District, Representative Griffey.
Mr. Speaker, thank you. Just to respond to what I just heard, every one of the schools that I mentioned have separate shower facilities. The only reason they can't do this, offer a reasonable accommodation that a separate shower facility is to be used, is because of the direction from our state superintendent of public instruction. So if we pass this, there will be options, Mr. Speaker. There will be options. There are options. Mr. Speaker, it doesn't have to be totality. It doesn't have to be that, yes, we don't have to tell our young ladies that you have to shower with somebody with a penis. We do not have to do that, Mr. Speaker. We can, if we pass this amendment, allow more options so more people are taken care of. Thank you, Mr. Speaker.
Further remarks, the good member from the 40th District, Representative Ramel.
Thank you, Mr. Speaker. Would you please excuse Representative Hackney?
The member is excused. Further remarks, seeing none, the good member from the 35th District, Representative Couture.
Thank you, Mr. Speaker. Rising in support of this amendment. You know, I think it's critical that we understand, Mr. Speaker, that the reason we have walls and ceilings and doors is so that we can have privacy and a safe space, especially when we're talking about using the facilities, the bathroom, Mr. Speaker.
Please proceed.
Thank you, Mr. Speaker. You know, it's important that although some people might feel comfortable, that not everybody feels comfortable. The bathroom, Mr. Speaker, is a safe space, especially for our young girls, especially when kids are going through puberty, especially when hormones are flying and raging in our high schools. I think that it's absolutely critical that we have separate sex bathrooms, but still provide accommodations for those who may be transitioning. For every one person that says they're comfortable with the current arrangement we have in our schools today, there are many more people who are not comfortable with it. Sometimes kids are coming home from school having held their bladders all day long because they're afraid of all the things that could be happening, whether it be showering with an opposite sex person, or whether it be using the bathroom with an opposite sex person, or whether it be the violence and the vaping and the drugs and the other things that are happening in our bathrooms and schools that are unsafe. Now, Mr. Speaker, a lot of these facilities can already be accommodated for and exist. The only reason schools aren't doing it, we don't have to build new showers and bathrooms. We just need to be set free from the threat of Chris Reichdahl and OSPI, who is threatening the funding of all the schools in Washington State if they don't follow his edicts and his radical ideology. Please vote yes on this amendment.
Further remarks, the member from the 25th District, Representative Jacobson.
Thank you, Mr. Speaker. Again, I've got 5 daughters, and they're all grown. What I wanted them to develop, Mr. Speaker, was a super active spidey sense. I wanted them to be able to kick up a ruckus when they needed to do so. I always counseled them, if you're being threatened or harmed, start breaking things. That'll get authorities there. So when I think about the idea that our gals in this state might be in a locker room with a boy who has his parts, and they might feel uncomfortable with that, Mr. Speaker, if it were my daughters, I would be telling them, kick up a ruckus, go ahead and say, no, I'm not comfortable with this. And that's what I want for our girls. I don't want them to be feeling like they can't protest this sort of thing because, oh, maybe that makes me bigoted or something. Everybody wants to be kind to everybody else, but we've got to do something about separation because I don't want my daughters or my granddaughters to feel like they can't protest something that makes them uncomfortable and should indeed make them feel uncomfortable. So I urge a yes on this. Let's not have boys in the girls' locker room. Thank you, Mr. Speaker.
Further remarks, the good member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker. So I wanted to talk with you just a little bit here about the mechanics of how this is currently being implemented in our schools. So let's just say there's 30 people that need to go use a locker room, need to go shower. Let's say that 2 of those people are actively transitioning. If there is a concern, we would expect that the people objecting go find somewhere else. The school would provide a separate shower for the ones objecting to showering if there is a different genitalia, if there's a transitioning person that makes them uncomfortable. Not only are we making the ones that object go find somewhere else outside of the space that is designated for them on the door, there are reports that I have received, I remember hearing them when I was on the school board, of staff looking down, belittling, whispering about the students having issues being in those locker rooms, about not just going along with it. If we were to have, this is again a hypothetical, if we were to have a 30-person locker room, 30 people going in, 2 trans students, and the other 28 objected, we would require all 28 of those students to go somewhere else and shower for the 2. This amendment would fix that and would say that we will accommodate the people that are going into the locker room, into the private space that is designated for them. We wouldn't belittle them. We wouldn't make them go find alternative arrangements. With my own teenage daughter, and soon to be 2 teenage daughters, what this turns into is coming home to shower, not showering at school. We don't need to be doing that. We have these spaces designated for a reason. Let's adopt this amendment and just move forward. Thank you.
Further remarks? The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. I want to address this issue of potential litigation. Oh, by the way, it's a good amendment, vote yes. The risk of litigation is not adopting this amendment. Mr. Speaker, we have right now a burgeoning flashpoint in this matter of how we treat boys and girls and men and women. As you well know, Mr. Speaker, at the federal level, the government has taken a pretty strong position that men are men and women are women, and men should not have access to women's sports. And, Mr. Speaker, I believe that the opposite perspective being articulated by the current superintendent of public instructions in our state is the real risk of litigation. Now, the collateral damage in all of this, Mr. Speaker, are the 295 school districts in our state. Because while the superintendent of public instruction carves out an extreme position on the matter of men and women's locker rooms and boys and girls' showers, the school districts themselves are the entities most likely to suffer the lawsuits when, as you've heard already testified, the district administrators believe that the superintendent's threats compel them to force boys into girls' locker rooms, or to say more appropriately, force girls to shower with boys. The school districts will suffer the lawsuits. The school districts will suffer the clash between the federal government and our state superintendent of public instruction. One wonders, Mr. Speaker, what that fellow's motive is here. But the risk of litigation doesn't fall on the federal government, and it doesn't even fall on the state government. The risk of litigation falls on the school districts, who are compelled to do something that is dubiously legal and certainly immoral. That's where the risk of litigation lies. You can manage that better by voting yes on this amendment, and you increase the risk by voting no.
Further remarks? The good member from the seeing none. The question before the House is adoption of Amendment 1168. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment 1165. Clerk will read.
On page 5, line 10 of the striking amendment.
Last line.
Internal references accordingly.
Good member from the 26th District, Representative Caldeir, to move adoption of the amendment.
Thank you, Mr. Speaker. I move adoption of Amendment 1165.
It has been moved and seconded that Amendment 1165 be adopted. Remarks. Representative Caldeir.
Thank you, Mr. Speaker. So this amendment would prohibit pornographic, sexually explicit material in the schools. I don't know about you, but I have received a number of parents concerned about some of the materials that either their children, their nieces, their grandchildren have had in the schools. In addition, in 2011, the federal government passed the Children's Internet Protection Act. And what that did was it said that all of the schools can receive a e-rebate for if they complied and had filtering mechanisms put on the internet for schools. So there has recently been a little bit of a backlash on, some people claiming that it filters too much. And currently, right now, we do not have, I could not get the exact number of schools, but right now we have 40 to 50 schools that are not currently getting the e-rebate. And I'm concerned that if this grows, that more and more children will have open access to the internet, and that is not a good thing for our state. So I urge adoption of this amendment. Thank you.
Further remarks, the good member from the 49th District, Representative Stonier.
Thank you, Mr. Speaker. Asking you to vote no on this amendment. The concerns raised are fair. However, in this state, the people of the state affirmed their support for making sure that students have accurate information education that is confirming what we know students should know in their comprehensive health and sexual health education. This was a bill that was passed several years ago and then defended at the ballot, so we know that students need that information. This amendment does not include a clear definition that would help distinguish between the things that people might come across that are very concerning and are not appropriate for young children, and also include the materials that may be used in biology, in health, in social services, and so I'm asking you to vote the amendment down.
Further remarks, the good member from the 20th District, Representative Orcutt.
Thank you, Mr. Speaker. Rising in support of this amendment. You may recall when we had the debate on 1296 and on one of the amendments, I got up and described what some of those instructional materials were. I received a complaint from a constituent of mine who was very upset with some of the material that was being provided to 11th and 12th graders. He didn't really describe it to me until he actually sent me a picture of the comic book that was issued to 11th and 12th graders. What was depicted in one part of that comic book, part of the school curriculum, was a drawing of a woman who was not clothed. She was lying on her back. There was another person in the room with her, performing a sex act with her. This constituent was furious that this kind of material, it was a picture, it wasn't just a description. It wasn't just me or somebody describing it, having it in words. It was actually a drawing of this, a cartoon drawing. Real to life drawing. Very real to life. If you want to see it, I'll show it to you. But it was very real to life drawing. He was very upset that this was part of the school curriculum. And he was given no advance notice of it. None whatsoever. There was nothing instructionally important about this. And even if somebody thought it was important for biology or sex ed, or sociology or anything like that, it wasn't actually the curriculum for any of those. It was a curriculum for English. For English. Sexually explicit material used as curriculum for English. What parent could expect that that would be as part of the English curriculum? They might have concerns it would be part of sex ed, but this was English. This amendment is very important to protect against that kind of material being given to underage youth. Please vote yes on the amendment.
Further remarks, the member from the 49th District, Representative Stonier.
Thank you, Mr. Speaker. Asking you to vote no on the amendment. As an English teacher, I can tell you, after reviewing the process by which curriculum is formally adopted at the school district level, and there is a difference between that and optional choices. Anytime a parent objects to anything that I would have in my classroom or that they would find in the library or even bring into the school, I would absolutely support that parent's right to not have their student read that material. There's a difference between curriculum and supplemental materials.
Further remarks, the member from the 15th District, Representative Corey.
Yeah, thank you, Mr. Speaker. Urging a yes on this very common sense amendment. I think you and I can agree, Mr. Speaker, that I don't believe the intent of this amendment would be to get after medically accurate textbooks and diagrams, something that would be instructional in nature. I think what we're getting at is obviously something more lewd and inappropriate, pornographic materials. The good gentleman brought up an example, and that's just one example that we're hearing time and time again from our parents across the across the state. Excuse me. I would rather us err on the side of caution and maybe be a we'll get there, too prescriptive and risk maybe going a little too far in one direction in the hopes that we could actually protect our kids from some of these materials. And Mr. Speaker, the good gentlelady is right. There is obviously a difference in approved curriculum and supplemental materials. But the question we have to continually ask ourselves is, why are things of such graphic nature needed in school, whether it's for English, science, or any other class that may be taken? Our kids currently are not meeting basic education standards in a variety of areas. This seems to me a wholly appropriate amendment to rein in some of the excesses in this extra curriculum. And frankly, there's a good prescription in here, Mr. Speaker. If there are materials that are explicit, the parent should have to get advanced consent. It shouldn't be they found out, they grabbed it from a student's backpack, or it was brought home, or the kids were talking about it. We should be proactively going out and ensuring parental cooperation and agreement in these things. And yes, if that means that we pass an amendment that says, the pornographic materials can't be in school, that seems like a pretty common sense one to me, urging the body's adoption.
Further remarks. The member from the 35th District, Representative Couture.
Thank you, Mr. Speaker. Rising in support of the amendment. Frankly, Mr. Speaker, I just can't believe we even have to talk about whether there should be sexually explicit, illicit, or pornographic materials in schools, whether that be an actual pornographic image or a pornographic illustration. And the reason why we're talking about it, we have this amendment, Mr. Speaker, is because it is happening. It is happening, and there is no right under the underlying bill for parents to be to pre-approve if their student can even view some of these extremely sketchy materials. But Mr. Speaker, I've been told in district and in other forums that these pornographic or sexually explicitly illustrated books in some of the libraries in our schools are necessary for our LGBTQ kids. Mr. Speaker, there is no pornographic material that is necessary for a child. Can we preserve the innocence of a child in our public schools and not expose them to the genitalia of the opposite sex or other sex acts in books that they can find sometimes in their libraries? The process for finding these books in our schools is a broken process. To go over hundreds and hundreds and hundreds of books, and sometimes they just blanket accept them after doing a sample size of reviewing the books. They did this in one of my school districts where they looked at hundreds of books and they did a sample size of about 30%, and wouldn't you know it, of their sample size, about a third of them failed, and they just blanket accepted the rest. That's wrong. We got to protect the innocence of our kids, Mr. Speaker. We shouldn't have books with sex acts or explicit material without the pre-approval, at least, of a parent. I would argue we should never have those things in schools. It's wrong. We shouldn't even have to be debating this. It's sad that we are,
Will the member please speak to the policy at hand? Please proceed.
Thank you, Mr. Speaker. I do not believe that when I send my kids to public schools, which they go to public schools, that they should be able to go into the library and grab something that is sexually explicit with an illustration or otherwise without my permission at bare minimum. Please vote yes on this amendment, Mr. Speaker. This is absolute common sense.
Further remarks, the member from the 22nd District, Representative Parsley.
Thank you, Mr. Speaker. I'm rising against this amendment. I too have concerns that there's no delineation between sexual explicit material, erotic. We don't know if that's not going to sweep in science. I'm a scientist and I'm a medical professional. I have two reasons why this bothers me. The first is, very importantly, in high school and in middle school, I got turned on to science, the beauty of nature. And yes, that included DNA and biology and physiology and anatomy, and yes, reproductive health. I got through high school because I got that ignition. I became a STEM student. I worry if we shut this off, we will inhibit other students going into STEM or those currently there. So we have a workforce shortage in the medical world. We cannot shut that down. The second reason has to do with my mother, who was a middle school teacher. I admire her because she taught 6th, 7th, and 8th grade about the time when our bodies are betraying us and emotions are running wild. And she loved that age. But she would come home and tell stories about the information that students would pass in school. Some of this information was wrong. Some of it was misinformation. Where they were getting it from, even before the internet, older siblings, older students, TV, newspaper, it didn't matter. It was wrong. She believed, like I believe, all teachers should be teaching to the truth so that you can help the students at least resist some of this gossip train that happens in every school hallway. Lastly, in Texas, I just heard that they are making it illegal to show how to do a breast exam in high school, that it's too erotic. Did you know, Mr. Speaker, that breast cancer is the #1 cause of cancer in women and the #2 cause of death in women? By not allowing health teachers to be able to teach this very simple exam sets up the women and the young women in Texas to high risk of not catching cancer fast enough where it can be treatable and even curable. We have to be careful how we delineate erotic and sexual content. This amendment does not do that. Please vote no.
Further remarks, the member from the 6th District, Representative Graham.
Thank you, Mr. Speaker. I'm urging a yes on this amendment. I'm going to again point to growing up going to Washington State public schools. I attended those health classes, and they were anatomically correct. We understood very clearly the difference between male, female. What I will tell you is during that time, Mr. Speaker, our kids were not failing math. They weren't failing reading. We were doing very well in the schools because math and reading and science and spelling and those things were the focus, not what's in between somebody's legs or how they identify or how they don't identify or what book they can read or what book they can't read. The same materials that we're talking about right now at the time I was going to school would have been considered predatory. If you had teachers saying, don't talk to your parents about this, that would have been considered predatory behavior, and for good reason. If we're talking about breast exams in school, is that when we have males that are there? Mr. Speaker, when I was going through those health classes, that type of stuff was considered as far as what's reasonable and what's not reasonable. We didn't have children that had the high anxiety and the depression that our kids are dealing with now either, because they were allowed to be kids. They were allowed to explore things that are outside of adult issues regarding the bedroom. It has no place in our schools. That's something you rely on your parents, your family, your caregivers to talk to you about. Not in our schools when they should be focusing on math, reading, things that our kids are failing right now. So it's for that reason, Mr. Speaker, I'm urging a yes on this amendment.
Further remarks, the member from the 2nd District, Representative Marshall.
Thank you, Mr. Speaker. So, my entire adult life, for about the last 23 years, I have been treating human patients as a medical professional. One of those has, that experience has really kind of guided my thoughts here. I also have served time on a school board and dealt with this exact topic as a school board member. I also teach. I've been teaching for over a decade at the collegiate level in biology. I have taught reproductive health. I've been down this road for years. The clinical breast exam comments that we heard are the reason that it's no longer being taught in some areas or being done professionally is because there's good studies out there now that show that self-breast exams and clinical breast exams are just as good as nothing. The reason is that they detect benign lumps that result in increased treatments and biopsies and unnecessary medical procedures and increased cost. And really, it's the mammogram that you want to get. But that's a different subject. Where I'm getting with this is having taught biology, having taught reproductive health, sexually explicit images, objects are not required. There are ways to teach reproductive health without needing to introduce pornographic or sexually explicit materials. When I was on the school board, we do have a review that parents are allowed to come in, at least at the school district that I was on, where they can come in, they can review some of the materials. And that is the approved material that comes down from OSPI that is adopted by the school board and the parents during the curriculum adoption process. The problem is not necessarily just that material. The problem, where a lot of the concerns are coming from that we're hearing about today, are the supplementary materials. Just days after one of my own children went into a health class for reproductive health, I started getting notifications from other parents about some of the supplementary materials that are brought in. There's no reason that a sex toy needs to be introduced into a middle school environment. This happens. This is not part of the approved curriculum. These are the supplemental materials. Parents, if this is going to happen, have a minimum right to know and have the option to opt out. It's not necessary to do this, and if it's going to happen, parents need to know about it. I urge your adoption.
Further remarks. The member from the 26th District, Representative Caldeer.
Thank you, Mr. Speaker. I just want to let you know that when SEPA passed, that was challenged in the courts, and there are already definitions of what pornographic and sexually explicit material is, so we don't have to reinvent the wheel. So just want to let you know. Thanks.
Further remarks. Seeing none, the question before the House is adoption of Amendment 1165. All those in favor, please say aye. Aye. All those opposed, say nay. The amendment is not adopted. There are further remarks. There are further amendments. My apologies. Amendment 1166. Clerk will read.
On page 6, line 9 of the striking
Last
amendment,
line.
internal references accordingly.
Good member from the 6th District, Representative Graham, to move adoption of the amendment.
Thank you, Mr. Speaker. I move 1166.
It has been moved and seconded that Amendment 1166 be adopted. Remarks. Representative Graham.
Thank you, Mr. Speaker. May I read from the effect statement for accuracy?
Please proceed.
Thank you. This grants parents and legal guardians the right to request in writing a safety plan for their child, and if denied by the public school, to receive within 3 business days a written explanation for the denial and any options for appealing the decision. Mr. Speaker, this amendment is necessary. I'm relying on an instance that happened in my district where I had, it was initially grandparents that contacted me. They had a child in middle school who was standing in line waiting for the bus, and there was another child who was a known bully who actually took their grandchild and put him in a headlock and had a knife up to the kid's cheek and was threatening him while he was standing in line waiting for the bus. As you can imagine, the child was very upset, the parents were very upset, and it was understood that they were going to be doing something to prevent that behavior in the future. Well, lo and behold, the very next day, that same child was right back at the school again. Now, one can imagine, again, an 11-year-old child being a little concerned about that, having gone through that situation. Now the same person is back there again with nothing really happening to them. The parents were rightfully concerned for the life of their child. Mr. Speaker, to my knowledge, nothing ever ended up happening out of that situation, and it's my understanding that they did end up withdrawing their child from the school for that reason. When we have these bullying situations that happen, parents and the victim of this need to know that there's something that's being put in place so that they know when their child goes there that something is going to be done to protect their child when they're on school grounds. Please accept this amendment.
Further remarks, the good member from the 21st District, Representative Ortiz-Self.
Thank you, Mr. Speaker. Mr. Speaker, I'm going to respectfully ask for a no vote, not because schools do not do safety plans, but because the term safety plan is very confusing. As it is, we have numerous situations that people pull that word out in. Safety plans for 504s, for IEPs, for custodial situations. DCFS has some for sexual abuse. The courts. All over the place, we hear the term safety plan, and they mean something different for every one of those situations. Mr. Speaker, I write a lot of 504 plans. We put plans in place. We do a lot of remediation and restorative justice plans around harassment and bullying. We sit down with parents and write plans for when a child is being harassed. Mr. Speaker, one of the biggest complaints we get is that we can't tell the parent what is happening to the other child involved. So whoever started it or whoever is the one who's the harasser, we're not allowed to tell the other parent what consequences they're getting. A lot of that has to do with maybe the child has disabilities, maybe they have a 504 plan, maybe they're an IEP student, et cetera, but we're by FERPA not allowed to discuss any of that, and I understand the frustration parents feel when they want an immediate answer, they want to see justice. But Mr. Speaker, we have lots of ways that we address that. They're not necessarily called safety plans because of the confusion that causes, but there are numerous other ways that we address that, and I think this amendment would make it a little bit more confusing, requesting a no.
Further remarks, the good member from the 31st District, Representative Penner.
Thank you, Mr. Speaker. Rising in support of this amendment, I can understand the concept that safety planning may be confusing. I think many of us who have experienced bullying throughout our lives were confused about the situation in which a safety plan may have become necessary in the first place. I would also offer that if a safety plan is confusing, I'm confused to find this confusing plan on OSPI's website as a template for school districts to utilize in providing safety plans for students. Moreover, Mr. Speaker, I would point out that the amendment is not granting the right of parents to a safety plan. It's not granting the right of students to a safety plan. It's granting the right of parents to know if a safety plan is denied in whatever form that safety plan may take, even if it's a confusing form, to know why it was denied in writing. I believe, Mr. Speaker, that to know why a safety plan for my child or any child is denied is well within the right of parents of Washington State and should be enshrined within our law. This is not saying a safety plan must look like this. It's not saying what a safety plan must or mustn't look like. It's saying that parents, if you adopt this amendment, parents have a right to understand why a safety plan was or was not created for their children. Please adopt this amendment. Thank you.
Further remarks? Seeing none, the question before the House is adoption of Amendment 1166. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment 1154. Clerk will read.
On page 6, line 25 of the striking amendment.
Last line.
Internal references accordingly.
The member from the 35th District, Representative Couture.
Thank you, Mr. Speaker. I move adoption of Amendment 1154.
It has been moved and seconded that Amendment 1154 be adopted. Remarks, Representative Couture.
Thank you, Mr. Speaker. A little while ago, we were talking about absences from schools, and that's exactly what this amendment is about. We were told that, or I heard that, no student in our public schools is excused without everybody knowing, including the parents, and that's simply untrue. Permission to read.
Please proceed.
Thank you, Mr. Speaker. WASDA's Model Procedure 3122P includes the following language. Students 14 years old or older who are absent from school due to testing or treatment for an STD will notify the school of their absence with a note of explanation, which will be kept confidential. Students 13 years and older may do the same for mental health, drug or alcohol treatment, and all students have the right for family planning and abortion. All students have the right for family planning and abortion. That, Mr. Speaker, is WASDA model policy, which, by the way, we surveyed about 280 out of 295 of Washington's school districts and found that 81.7% of the school districts of the 280 that we surveyed out of the 295 have in force this exact policy, allowing any child, for certain reasons, depending upon their age, to simply excuse themselves from the school to go seek out what could be controversial services without the notification or consent of their parents. That's scary, Mr. Speaker. Once the child excused themselves at 9 years old for family planning and abortion reasons, who is keeping tabs on that child as they walk the street towards those services? Nobody. Nobody at the school. Their parents certainly don't know. Mr. Speaker, that's wrong. This is an egregious policy. It is absolutely outrageous that any child, for certain reasons that I outlined just a minute ago, could walk out of the school, excuse themselves without telling parents, so they can actually excuse themselves from school, Mr. Speaker. And that is exactly what this amendment would stop, that egregious practice. Let's keep our kids safe, Mr. Speaker. Let's not allow them to excuse themselves from school without parent notification. Vote yes on the amendment.
Further remarks, the member from the 37th District, Representative Santos.
Thank you, Mr. Speaker. Asking for a no vote. I think the good gentleman makes interesting points. But what I would offer you, Mr. Speaker, is the aim of his concern through this amendment is poorly placed. You see, Mr. Speaker, the rights whereof he speaks are not anywhere within 28A. The rights of which he speaks for the student of any age to seek birth control services, to seek abortion services, to seek gender care services are located in other parts of the code, which is not the subject of the bill before us. Mr. Speaker, the question around excused and unexcused absences, as he cited from the WASDA model policies, are state law, but the underlying bill does not attempt to change those state laws. Therefore, Mr. Speaker, I have to ask you to allow school districts to continue to do what they've been asked to do through the legislatures of bygone years and ensure that student privacy is protected. Please vote no.
Further remarks? Seeing none, further remarks? Seeing none, the question before the House is adoption of Amendment 1154. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment 1159, clerk will read.
On page 7, beginning on line 21 of the striking amendment, it's operation.
Good member from the 20th District, Representative Orcutt.
Thank you, Mr. Speaker. I move adoption of Amendment 1159.
It has been moved and seconded that Amendment 1159 be adopted. Remarks, Representative Orcutt.
Thank you, Mr. Speaker. During this debate on a couple of the other amendments, a couple of statements were made that I'd like to bring up. One was that we have the public's consent, and whether we do on that amendment or not, I don't believe we do. But certainly on this entire policy, we don't. And I think that proved out based on another comment that was made on the very first amendment, that 2081, the initiative to the legislature, did not go out to a vote of the people. And that's correct. It did not go out to a vote of the people. It was adopted here in the legislature. But Mr. Speaker, if we had not adopted that initiative here in the legislature, and we had this bill in the last legislative session, I believe that this would have gone to the ballot along with 2081. And then we would have found out whether or not we had the consent of the public on this entire proposal, or whether we had their consent for 2081, because they both would have gone to the ballot. Now, because it was passed last year, and this bill is coming up this year, that kind of goes around that process of any changes to that initiative going, any alternate proposal from going to the ballot. So I think it's really important, Mr. Speaker, to gain the trust of the citizenry of this state by putting this out to a vote of the people. I think the people will appreciate us putting it out and asking them. Because if we don't, they're going to look at this as an end run around what would have been the proper procedure for the initiative last year. They would have had the chance to vote on that initiative. They would have had the chance to vote on this. So I believe it's only fair, and I believe it's the one thing that we could do today that will earn the trust of the citizens of Washington State. This just sends it out with a referendum clause to ask for the people to vote on it and tell us whether or not we have their consent on this bill. I don't believe we do. The very least we can do is ask them. Please vote yes.
Further remarks, the member from the 21st District, Representative Ortiz-Self.
Thank you, Mr. Speaker. I'm going to ask for a no vote. Mr. Speaker, we need to legislate, which is what we were mandated to do. We have heard from the public, we have heard in committee, we have researched. Mr. Speaker, our school districts are asking us for clarity. They're asking us to clarify the mandates before them, and to the benefit of our schools, our parents, our teachers. We need to act on that. And so we knew that we were going to pass that, but we also knew that the language was not clear, and if it caused problems and we weren't able to get uniformity across the state, that we would have to come back and fix that. We made promises to school districts that we would come back and fix it if it was unclear, and they clearly spoke and said it was, and so we are doing that now. We are trying to make it clear and not conflict with our existing laws, and so, Mr. Speaker, I'm asking for a no.
Further remarks? The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Great amendment. Please vote yes. Mr. Speaker, your and my constituents are not school districts. Our constituents are the people of the state of Washington. Now, it's good to hear from the school district bureaucrats. They have to deal with public policy, and it's important to know what they have to say about it. But they aren't our constituents. Our constituents are the people. And it's the people whose voice should be heard on such an important point in public policy. I mean, yes, providing high-quality basic education is the paramount duty of the state government, and in most contexts, that is us, this legislature, this building, the people in the corner offices. But ultimately, Mr. Speaker, it's the people in whom all political power is inherent. I know you know that, Mr. Speaker. You didn't check your notes for that because you know Article 1, Section 1 of the state constitution. Mr. Speaker, this is important. I mean, all kidding aside, this issue is of primary importance to the people of Washington. They are our constituents. They are the ones, I believe, who should have a clear say on this matter. And they are the ones who've told me, and I'm sure that your experience has been similar, they want the clarity of current law of the Washington State Parents' Bill of Rights. The confusion is in this underlying bill. So let the people speak. Let's respect the democracy that is part of our constitutional republic. Let's respect the democratic institution of the referendum process. Let's find out what the voice of the people says. Even when I don't agree with it, I respect it and I honor it, as I know you do too. Let's let the people speak on this issue. Let's vote yes on this amendment and make sure that the people are heard on this issue. Please vote yes.
Further remarks? Seeing none, the question before the House is adoption of Amendment 1159. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment 1156. Clerk will read.
On page 4, beginning on line 14 of the
Last
striking
line.
amendment, 15 and insert sub H2.
Good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. I'd like to move Amendment 1156 for adoption.
Amendment 11, it has been moved and seconded that Amendment 1156 be adopted. Remarks, Representative Walsh.
Thank you, Mr. Speaker. This amendment clarifies what is surely confusing material in the underlying proposal. And this has to do with questionnaires and surveys that some teachers, some administrators, some school districts, some bureaucrats at education service districts, and some superintendents of public instruction in our state put forward. These questionnaires, these surveys, are nominally teaching tools, but really there's a great deal of uncertainty even among credentialed experts about how effective they are as tools in that capacity. But they tend to focus on issues that are outside of what some of us consider basic education: reading, writing, math, and the hard sciences. These surveys and questionnaires sometimes have to do with personal matters: one's own sexuality, one's own sexual thoughts, one's own notion of sexual identity. Some of these questionnaires have to do with other material, one's family. What do you do at home? What are your common practices at home? What are your religious practices at home? What are your tensions at home? Now, Mr. Speaker, in some cases, these questionnaires, these surveys, may be intended to help a student, to help people with their development. But, Mr. Speaker, they are an inappropriate tool, in most cases, in many cases anyway, to the charge that you and I share of providing high-quality basic education to all the children in the state. These questionnaires, they are controversial by definition, and we should not rely on them. We should not count on them, and if they are to be used, they need to be used in very measured and limited ways. What this amendment does is it sets clear guidelines so that we don't have to worry about confusion about how these questionnaires and surveys can be used in our schools. It is a clarifying amendment to confusing language in the underlying proposal. Please vote yes.
Further remarks. The member from the 30th District, Representative Reeves.
Thank you, Mr. Speaker. I'm going to respectfully ask you to join me in voting no on this amendment. What the good gentleman is referencing in this amendment is protections in federal law for me as a parent to provide consent for said surveys to even be administered to my child. Mr. Speaker, the purpose of this underlying policy is to ensure that we are amending the Parents' Rights Initiative to bring it into alignment with existing law. Well, Mr. Speaker, the Pupils' Bill of Rights at the federal level is U.S. law. It's gone through Congress, it's been signed by a president, and it's enacted by the U.S. Department of Education. The Pupils' Bill of Rights, Mr. Speaker, outlines 8 very important areas of protection. Things like, you shouldn't be asking my kid about their political affiliation without my consent. Mr. Speaker, you shouldn't be asking my child about their home life or their taxes, my taxes, without my consent. What I love about the Pupils' Bill of Rights, Mr. Speaker, is that embedded in it are my rights as a parent to know what those surveys' contents are and actually have proactive rights to provide permission on whether or not my children should be allowed to take those surveys, Mr. Speaker. So I'm asking you to join me in voting no on this amendment, because why, Mr. Speaker, would we remove limitations that constrict this alignment to federal law? If the purpose of the underlying bill, Mr. Speaker, is to ensure that we're aligning with federal law, what better way to do that than to limit it to those 8 core rights in the PPRA? So, Mr. Speaker, please join me in protecting my rights as a parent of kids in our public schools by voting no for this amendment.
Further remarks. The Representative Defoe.
Thank you, Mr. Speaker. The good lady who spoke before me said that the purpose of this bill is to bring clarity. I believe, Mr. Speaker, the purpose of the underlying bill is hypocrisy, is betrayal, is trickery. Mr. Speaker, this amendment makes sure that parents do not have to subject their children or allow their children to be subjected to objectionable material in surveys, in push polls that I have read about, that I've seen presented to me from my own children's public school. Mr. Speaker, please vote yes on this amendment so parents remain invested and fully aware of everything that is coming before their children.
Further remarks. The member from the 19th District, Representative Walsh.
Just a clarifying
The member
point.
has 17 seconds remaining.
Thank you. Vote yes. Current law is the initiative, and it protects families from these invasive surveys. And we need to be doubly careful that we protect them because of conflicts with federal law at the state bureaucratic level. Thank you.
Further remarks. Seeing none, the question before the House is the adoption of Amendment 1156. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are further amendments. Amendment 1158. Clerk will read.
On page 7, beginning on line 6 of the striking
Last line.
amendment, strike meaning as in RCW 28A.150.010.
Representative Defoe to move adoption of the amendment.
Thank you, Mr. Speaker. I move adoption of Amendment 1158.
It has been moved and seconded that Amendment 1168 be adopted. Correction, 1158 be adopted. Remarks. Representative Defoe.
Thank you, Mr. Speaker. This amendment makes sure that when a school district or a teacher or an administrator violates what's left of the Parents' Bill of Rights, that they have a remedy, that they have the opportunity to correct what is prohibited by state law. The bill, as currently drafted, states that the parents or anybody else hurt by this bill have no right to enforce the harm that's been done. They have no right to fix the harm that's been done. They have no right to correct the violation of state law that has occurred against their children and against their families and against them. Please vote yes on this amendment so that the parents or anybody else harmed by this bill, what's left of it, have the opportunity to fix the problem and enforce state law.
Further remarks. The good member from the 46th District, Representative Paulette.
Thank you, Mr. Speaker. Mr. Speaker, this legislature has generally limited private rights of action against school districts for a plethora of very good policy reasons. Can't go into all of them right now in 3 minutes or less, but the legislature has explicitly stated, for example, that we limit them to the laws against discrimination for very good reasons. We don't, and we have said there's no private right of action for other school provisions, including ones I think are very important, such as adequate school heating, lighting, environmental health, even for many of our provisions about whether or not a child who's entitled to an individual education plan gets the services they sought. We do have a general statute, 28A 645.010, allowing any person aggrieved by a school board to file a suit following that procedure. That is adequate if you can show harm, not just a violation of an expectation in a state law, such as should the heating be generally at 65 degrees, or any other aspect that might be embodied in a state law, including the one in front of us. So I ask for a no vote. Thank you.
Further remarks. Representative Defoe. The member has just under 2 minutes remaining.
Thank you, Mr. Speaker. My friend, the good gentleman from the 46th District, I think illustrated a big problem that hopefully this amendment can fix. We have inadequate accountability in our public school systems. Let's not extend that lack of accountability, that increase in poor outcomes, the lack of parent input and buy-in, the lack of community support and continually declining community support for our public schools by accepting this amendment and saying when there is something going wrong in our public schools, parents have a way to fix it. Vote yes.
Further remarks. The member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Vote yes on the amendment. Let's go back to the beginning of our discussion of this policy. Parents are the primary stakeholders in the upbringing of their children. We have to honor that principle, Mr. Speaker, in our public policy, and this amendment honors that principle. Parents are the primary stakeholders in the upbringing of their children. Please vote yes.
Further remarks. Seeing none, the question before the House is adoption of Amendment 1158. All those in favor say aye. Aye. All those opposed say nay. No. The amendment is not adopted. There are additional amendments. Amendment 1160. Clerk will read.
On page 7, beginning on line 21 of the striking amendment, all of section 3.
Good member from the 7th District, Representative Ingle, to move adoption of the amendment.
Thank you, Mr. Speaker. I move Amendment 1160.
It has been moved and seconded that Amendment 1160 be adopted. Remarks, Representative Ingle.
Thank you, Mr. Speaker. The bill before us today is seeking to amend the current law that came from initiative I-2081, what more than 400,000 people signed. I've heard from people from every corner of my district, largely parents, concerned about what this bill could do. I'm asking for an adoption of this amendment to remove the emergency clause so that if people so choose, they can send this to the people for a vote on a referendum. I'd encourage its adoption.
Further remarks. The member from the 49th District, Representative Stonier.
Thank you, Mr. Speaker. Asking you to vote no on this amendment for a couple of reasons. First and foremost, the lack of clarity since the passage of initiative measure number 2081 has caused confusion and needs to be addressed. This is confusion that we know was coming because we asked the questions initially. And now at this point in time, schools are asking for direction so that they are clear. In order for it to be clear, we must pass this measure in a way that provides immediate clarity, and that's why the clause is included. Secondly, their confusion is rooted in whether or not law has been changed. Again, these are questions we asked initially, and they have become clearly confusing. You cannot change healthcare law without passing a bill related to healthcare. You cannot change the law with regard to whether or not students, young people, who are found to be in an unsafe and very risky environment and need the protection of a place to go. Cases that are very rare, and cases where the state agency who is taking those students into care have to report to parents that they are safe. In these types of rare cases that have been debated, the law has been clear because the bills that made them so passed. And when the initiative passed, it called into question whether or not those laws were changed. They were not. It is imperative that we pass this bill with the emergency clause because people need the clarity now. Please vote no on the amendment.
Further remarks. The good member from the 20th District, Representative Orcutt.
Thank you, Mr. Speaker. I would argue that the only urgency is to know the opinions of the public on this. As the gentleman from the 19th talked about, it's our constituents, the people who live in this state, the people who send their kids to school. They were given certainty under 2081. This bill takes that certainty away. Is this the right policy? If it's the right policy, it will withstand a vote of the people. And if it's that right of a policy, Mr. Speaker, then anyone opposed to it would not be able to get enough signatures to even put this onto a ballot. And then it would go into effect. It would go into effect long before the school year starts. Mr. Speaker, an emergency clause makes it difficult, if not impossible, for the people to step up and say, no, we want to vote on this. We didn't adopt the amendment for the referendum, so we're not automatically going to put it out. But the very least we could do is to remove the emergency clause and allow the people to determine for themselves whether they want to vote on this or not. And if they do want to have a vote on this, then it gives the opportunity for everyone in the state to have a robust discussion over whether or not this is the right policy. And if it's not the right policy, that robust discussion would give us guidance to come back here in the next year and create the policy that is right for the people. I ask you, Mr. Speaker, to adopt this amendment. Do not lock out the citizens of this state from having the final say on this policy. I believe that's the least that they deserve. I think they deserve a lot better, a lot more. But at the very least, don't take away their right or their ability to have the final say. Please adopt the amendment.
Further remarks. The member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Good amendment. Please vote yes. Let's respect our democracy and allow the people to have the option of a voice in the final reckoning of this underlying proposal. Mr. Speaker, we've heard a lot of complaint about confusion caused by the Parents' Bill of Rights. Mr. Speaker, I would posit to you the confusion is the result of incompetence and ineptitude from Chris Reichel in the Office of Public Instruction. Their guidances have been a mess of illogic and confusing instruction. Ironic, isn't it? If we want an emergency, the emergency is what's going on at OSPI, and not the rank and file policy people there, Mr. Speaker, but at the top, there has been confusion, obtuseness, willful misunderstanding. That's the emergency. Let's focus our emergency clause where it belongs. Let's remove it from the underlying policy and give the people of the state the right to fix what's broken, and that starts in the corner office at OSPI. Please vote yes.
Further remarks. The member from the 49th District, Representative Stonier.
Thank you, Mr. Speaker. I demand the previous question.
Do 1/6 of the members demand the previous question? Members who demand the previous question, please stand and remain standing. Members, please be seated. At least 1/6 of the members have demanded the previous question. The Speaker will now put the previous question to the House. As many as are in favor of ordering the previous question, say aye. As many that are in favor of ordering the previous question, please say aye. Aye. As many as are opposed to ordering the previous question, please say nay. The Speaker is in doubt? No. We will go to division. The Speaker is about to start the roll call machine. The Speaker has started the roll call machine. Has every member who wishes to vote voted? Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. The ayes have it. The previous question has been ordered. Now the question before the House is the adoption of amendment number 1160. All those in favor, please say aye. All those opposed, please say nay. The amendment is not adopted.
The House will be in order. There are no further amendments. Well, that's not totally true. We are now, the question before the House is the adoption of the Education Committee amendment as amended. All those in favor say, hold. Now the question before the House is adoption of the Education Committee amendment as amended. An oral roll call vote has been requested. Members, when voting, must stand and only say aye or nay, nothing more. Please proceed with the oral roll call vote.
Abarno. Abel. Barkis. Barnard. Callan. Chase. Connors. Corey. Cortez. Couture. Davis. Dent. Dolio. Donaghy. Dewar. Dufault. Dye. Engel. Entenmann. Eslick. Farvar. Pye. Fitzgibbon. Fossey. Goodman. Graham. Gregerson. Griffey. Clicker. Levitt. Lakanoff. Lee. Lowe. Macri. Manjarez. Marshall. McClintock. McIntyre. Mena. Morgan. Nance. Obras. Orcutt. Ormsby. Ortiz Self. Parsley. Paul. Penner. Peterson. Paulette. Rammel. Reed. Reeves. Richards. Rude. Rule. Ryu. Salahuddin. Santos. Schmick. Schmidt. Scott. Shavers. Simmons. Springer. Stearns. Steele. Stokesbury. Stonier. Street. Stevie. Taylor. Ty. Theringer. Thomas. Timmons. Voles. Wallen. Walsh. Waters. Wiley. Ibarra. Zahn. Madam Speaker.
Will the clerk please report the record?
Madam Speaker, there are 92 yeas, 3 nays, 3 excused.
And with that vote, the committee amendment as amended is adopted. Good member from the 49th District, Representative Stonier.
Thank you, Madam Speaker. I move that the engrossed second Senate Bill 5181 as amended be advanced to third reading.
It's been moved and seconded that engrossed substitute Senate Bill 5181 be advanced to third reading. An oral roll call vote has been requested. Members, when voting, only say aye or nay, nothing more. Please stand as you vote. Will the clerk please begin the roll call vote?
Abarno. Abel. Barkus. Barnard. Berg. Bergquist. Birnbaum. Berry. Bronowski. Burnett. Caldeer. Callan. Chase. Connors. Corey. Cortez. Couture. Davis. Dent. Dolio. Donaghy. Dewar. Defoe. Dye. Engel. Entenmann. Eslick. Farvar. Fye. Fitzgibbon. Fossey. Goodman. Graham. Gregerson. Griffey. Hill. Hunt. Jacobson. Keaton. Clicker. Levitt. Lakanoff. Lee. Lowe. Macri. Monjarez. Marshall. McClintock. McIntyre. Mena. Morgan. Nance. Obrus. Orcutt. Ormsby. Ortiz. Hall. Penner. Peterson. Paulette. Rammel. Reed. Reeves. Richards. Rude. Rule. Ryu. Salahuddin. Santos. Schmick. Schmidt. Scott. Shavers. Simmons. Springer. Stearns. Steele. Stokesbury. Stonier. Street.
Families against the school districts and the school board. You know, I've been a Washington resident my entire life. I was born in 1965, and I've seen a lot of stuff going household and the family and our education system. So I urge you to vote no. I ask everyone to vote no on this bill. Thank you.
no on this particular bill. You know, I was a school board member in my hometown for 9 years. I was very proud of that, and we did a lot of very good things in my hometown because we listened to the parents. We gave them the information they needed. We gave them everything they needed to make sure that their kids were at school every day, that their kids were learning every day. Our grades were going up. Our numbers, our SBAC scores were just doing a great job. I think that this legislation in front of us is going to not make that happen. I think we've seen other legislature in the past that has done that, and we can look at SBAC scores and things like that to show that
today is I worry that this bill may not cost us today, but down the line, this bill is going to cost my district's ability
They were new to this country, and
they were navigating an extremely complex system. A system which even native English speakers who don't have children in special education have a hard time moving through. Imagine the challenges faced by these families. I learned quickly that these parents' basic civil rights were not being honored, nor were they even being informed that they had these rights.
This bill is keeping, the effect of this bill basically is keeping information from parents. This bill actually
Thank you, Madam Speaker. Few things get people worked up as much as concern for their children or how they're impacted. And most people
primary stakeholders in the education of their children. Well, I don't disagree with that. Today, though, we need to bring clarity and apply their minds and their bodies to the only job we ask of them, which is to learn in our schools. Right now, we see so much evidence that that is not taking place. There's anxiety, there's depression, there's suicidal ideation, and what's worse, Madam Speaker, that is why it takes a team, Madam Speaker, and we cannot allow the rules to be so obscure or obscured by generalized terms or by language of the law that seems to conflict with other laws. Madam Speaker, 5181 provides that clarity. 5181 provides that alignment. Madam Speaker, I ask for you to support 5181 for the good of our children.
Further remarks? The good member from the 8th District, Representative Barnard.
Thank you, Madam Chair. I'd like to start with some really, really good statistics and make this positive. Permission to read?
Please proceed if it's relevant.
Students involved with parents, or students that have parents that are involved, are 81% more likely to graduate. 44% increase in post-secondary education, a 20% decrease in absences, 62.1% of students agree that parental involvement boosts their self-esteem, enhances school engagement, and it improves or increases their positive attitude toward learning, and they have stronger social skills. So parents that are more engaged, more involved in their students' and their child's education have higher success rates in education and in life. The reason why this cuts so closely to the core is because it is our sacred responsibility as parents, our duty as parents, as outlined in not just Holy Scripture, but in law. We have a responsibility to raise our children well as we can, to provide for them home, love, comfort, food, a roof over their heads, clothing, all of the essentials. This bill is creating a wedge. It's putting a wedge between parents and their children that, I think it's a negative way of looking at the responsibility of parents and the responsibility of our schools. Sure, we need our schools to help educate our kids. My kids have all gone through public schools and had a wonderful experience. But I feel like the schools should not operate under the premise that the parents are bad or dangerous. That type of premise, again, creates that wedge. We should be doing everything possible to strengthen the parent-child relationship, not create wedges. Vote no.
Further remarks, the member from the 15th District, Representative Defoe.
Thank you, Madam Speaker. This bill sidelines hundreds of thousands of parents from across Washington state. This bill silences hundreds of thousands of parents across Washington state. This chamber has existed for over 130 years, but for the first time in its history a few moments ago, debate was silenced. Debate was censored.
Please speak to the policy. Please proceed.
This bill led to the censorship of representatives of the people of Washington state who strongly supported the initiative and who opposed this bill. On a debate about an emergency clause, taking that out, an amendment that would have taken out the emergency clause and would have allowed, finally, the people of Washington state to vote on a referendum undoing this bill, was not accepted and can now not be considered by the people of Washington state. Madam Speaker, the legislature passed this bill rather than let it go to the people. The people continue to be obstructed by this chamber by not voting on.
Please do not impugn members. Further remarks, the member from the 25th District, Representative Jacobson.
Thank you, Madam Speaker. So I agree with the previous speakers, and I'll try not to repeat. The voters who passed Initiative 2081, I don't think that they were confused, and I do think that parents are the primary stakeholders in their children's education. But Madam Speaker, some of the reasons for my no on this bill are the amendments that were not taken. Madam Speaker, boys don't belong in girls' locker rooms. Boys don't belong on girls' sports teams. Pornography does not belong in curriculum. Children under 12, Madam Speaker, children who are in elementary school, the parents of those children deserve to be notified when those children are given medical supplies or given treatment. The parents deserve to be notified. Under 12, that amendment was not taken. The parents have the right to records, all the records, Madam Speaker. The parents are the primary stakeholders in their children's education. The parents have a right to be notified when their children are taken off campus. They don't need to wait 72 hours wondering where their child has gone if they've dropped him or her off at school. So, Madam Speaker, I agree with what my colleagues are saying about the reasons for no on this bill, and I would also add that we need to reorient our thinking to what average parents are worried about in schools. Average parents in my district come up to me at the store, and even parents whom I know to be from the other party come up to me and say, "What is going on?" Average parents, we need to realign our thinking with average parents who just want to know what's going on at their children's school. So, Madam Speaker, I would urge a strong no on this. Thank you.
The member from the 6th District, Representative Graham.
Thank you, Madam Speaker. It's hard for me to contain emotion right now. The last time we spoke about this, Madam Speaker, I wasn't able to speak. I'm standing up for the detransitioners because the last time we spoke, it was National Detransitioner Day. Madam Speaker, this is personal to me. I'm dealing with this in my family, and I care. I care that what happens to the children who we go through different phases in our life. Some of these phases, though, Madam Speaker, are permanent. Some talking about their lived experience. They're talking about the things that have happened to them. They're talking about regrets that they have. And they're talking about things that they can't take back. Madam Speaker, if an adult decides to make a decision for themselves, that's up to them. I'm speaking right now for the children, that somebody has to stand up. This is the one issue, Madam Speaker, that
what role do they play? Madam Speaker, I feel like it's being pushed away from let's bring inclusion. I hadn't heard, maybe I just wasn't paying attention to, but when I've heard in this chamber, one in committee, that says nothing about us without us. And I'm afraid, Madam Speaker, that this doesn't speak to that here in ESSB 5181. So I urge you to vote no, Madam Speaker.
Further remarks, the good member from the 13th District, Representative Dent.
Thank you, Madam Speaker. I'm taken back today by this debate, by the amendments that I've heard. I guess, I'm a little bit
several kids, school-age kids, that are currently homeschooled. And the very reason they're homeschooled was because of the continued erosion of what we continue to drive those numbers down and away as parents look for places that they can have their kids in schools where they can know what is going on, is their right, and it should be the school's obligation to provide that to them in this state. Please vote no.
The good member from the 19th District, Representative McIntyre.
Thank you for the recognition, Madam Speaker. I know I've said before on legislation, oh, this is the worst bill I've ever seen, but really, Madam Speaker, like, it's getting worse. This is the worst one that I've seen since I've been here. The failure of adopted amendments alone is worthy of rejection of this bill. I mean, really, Madam Speaker, like, I feel like any minute now I'm going to wake up from a fever dream and be like, I can't believe it, what the dream I had, where, I mean, who could have had this on their bingo card, that gun-toting, Constitution-quoting, meat-eating MAGA Republican Joel McIntyre, defender of women's rights. I thought that real estate was taken, but I'll have it. I'm defending women's rights and the rights of our daughters, our nieces and our granddaughters, for their place to be able to be safe and secure in their spaces. And that was on an amendment that failed. I'm waiting to wake up. I can't believe that it failed. Had it been adopted, still wouldn't have voted for the bill. It's still no good. But the failure of the adoption of those amendments, I'm stunned and I'm in disbelief of where this legislation has taken us. Madam Speaker, I hate losing. I'm hyper-competitive. I've lost friends and almost lost family because of it. It's a problem that I have, but I hate losing. I sit on the Education Committee, and the focus of my place here in the legislature of so many issues is I want so badly to fix our education system, and Madam Speaker, we are losing. And I'm losing because I'm a part of the committee. I bear responsibility for the failure where we're at right now in the state, and our kids, my kids. This isn't going to help us. I know it, and I think you know it. You honestly believe, Madam Speaker, that when this passes, that parents who have taken their kids out of school are going to say, oh, we got to put them back in? No, quite the contrary. More will leave. And we'll scratch our head and say, how did this happen? What do we do? We're losing in students. We're hemorrhaging students. The parents even more have lost trust in us because of this, among many other things. I just want to win, Madam Speaker. I want to see our kids come back and lead the country in academic outcomes, prosperity. But this isn't it. This ain't it. I'm sorry that kind of breaking here, but I just wish things were different. Please vote no.
Further remarks, the member from the 49th District, Representative Stonier.
Thank you, Madam Speaker. Rising in strong support of this bill, may I have your permission to read some of the rights that are in the bill?
Please proceed.
Some of the things the bill says as it stands before you, Madam Speaker. Parents are the primary stakeholders in their children's upbringing. Parental involvement is a significant factor in increasing student achievement, and access to the student information encourages greater parental involvement. Unchanged. Madam Speaker, the bill also says to inspect and review a child's education records within a reasonable amount of time. That is a right that is upheld in this bill. Madam Speaker, also parents have the right to receive immediate notification if criminal action is alleged to have been committed against their child, Madam Speaker. Parents have the right to receive immediate notification if law enforcement personnel questions their child, Madam Speaker. Moving on. Parents have the right to have their child receive a public education in a setting in which discrimination on the basis of sex, race, creed, religion, color, national origin, and beyond is protected. Madam Speaker, parents also have the right to opt their child out of any survey, analysis, or evaluation that reveals information about a list of things that this body has put forward. Now, I could go on about the parental rights that are listed in this bill, like to have their student opted out of sexual health education. Madam Speaker, I have not once argued that parents are the primary teachers in a child's life. And I have never, as a public school teacher, not thought to myself when I have a challenging moment with a student, what I could learn from calling home to be a stronger support for that student in their learning and in their school setting. Madam Speaker, this bill upholds those parental rights, and it also clarifies things that have been confusing about certain parts of the law that were not changed by the initiative. And those are the two reasons I ask you to vote for the bill.
Further remarks, the member from the 9th District, Representative Dye.
Thank you, Madam Speaker. I was one of those parental outcasts in public school. I failed in first grade when the first weekly weeder came in and there was a polar bear on an ice cap, and maybe I'm too sensitive. I didn't say anything to the school, but I did at the point when my little first grader was told she needed to see a psychiatrist, and maybe that's part of the crazy of being an older parent, but I wanted to opt out of that and wasn't given that option. You know, in the school system, I've just seen the change over time where we've lost the commonality of the social compact, where the adults are the people in charge and the kids need to learn to get with the program, and the program is well formed. But when the value systems aren't alike or aligned, you see, what we've seen, and you've seen the initiative put forward. You saw us vote that across the floor of this House. You've seen the appropriations bills that have come in with 58,000 ghost students being funded, the 58,000 families that did not return back to the public school system, the difficulties that we're experiencing in some school districts where parents feel alienated and not listened to. And that's what we're dealing with today with the bill that's before us. We're dealing with the fact that parents wanted to have the authority to direct the moral and cultural upbringing of their children, and that they used to be able to do that in an era before when there was a common cultural construct that held us together. And we're seeing those differences today on the floor as we went through those amendments. You know, for people who believe the way I do, find it a little shocking that you wouldn't want the girls to have privacy as they're going to their first PE classes in 7th grade, and how embarrassing and struggling that would be for a kid that's shy like myself. I would have died a million deaths. How we can't ultimately protect our children from ideas that are capturing the mind through social media, that maybe they're not okay as being a little boy and maybe they ought to be a little girl, and how that's affecting the well-being and the mental health of normal kids and not well-adjusted kids. And so to me, I understand why parents are wanting more capability of influencing the culture in their school system. I remember the last event that happened in our family. Well, I won't go there. Just please join me in voting no against this bill and give the parents back the rights that you gave them last year. Thank you.
Further remarks, the member from the 35th District, Representative Griffey.
Well, thank you, Madam Speaker.
I rise in opposition to this bill, and I agree with the good gentlelady from the 49th district. The parents do have the right under this bill to receive notification about how their kids are doing or request notification in 45 days. Madam Speaker, 45 days is nearly a third of the school year, and if a parent wants to help get some remediation or tutoring for their kids, they have to wait 45 days to get the data to give to somebody that they're going to help remediate. I'm also against this bill because we failed to accept an amendment that I think would protect sexual assault survivors and allow our girls, it to be the norm that our girls do not have to shower with transitioning males that have intact parts. By default, right now, Madam Speaker, they have to shower with them. Our superintendent of public instruction have told our school boards that if you don't make them shower with them, Madam Speaker, he will cut off the funding to the schools. Madam Speaker, sexual assault survivors should be respected, and our parents should be respected more than that. If a parent is concerned that their kid is not doing very well in school, it should take no time to get their progress reports out to them so the parents could then make the decision whether or not to get remediation training for them. Furthermore, Madam Speaker, a young sexual assault survivor should not have to walk into a shower room for the first time and see the male appendage without being notified, without being prepared, while they're showering in schools. Madam Speaker, I vote no because there's not enough parental participation. Madam Speaker, I vote no because we should have a heck of a lot more parental participation. Thank you, Madam Speaker.
The member from the 49th District, Representative Stonier.
Thank you, Madam Speaker. I demand the previous question.
Do 1/6 of the members demand the previous question? Members who demand the previous question, please stand and remain standing. One-sixth of the members, at least 1/6 of the members, have demanded the previous question. The Speaker will now put the previous question to the House. An oral roll call vote has been requested. Will members simply respond by saying aye or nay, and please rise when they are casting their vote. Members in favor of ordering the previous question say aye. Those who are opposed to ordering the previous question say no. Will the clerk please call the roll?
Abarno. Abel. Barkus. Barnard. Berg. Bergquist. Birnbaum. Berry. Bernowski. Burnett. Caldier. Callan. Chase. Connors. Corey. Cortez. Couture. Davis. Dent. Dolio. Donaghy. Dewar. Defoe. Dye. Engel. Entenmann. Eslick. Farvar. Fye. Fitzgibbon. Fossey. Goodman. Graham. Gregerson. Griffey. Hill. Hunt. Jacobson, Keaton, Clicker, Levitt, Lakanoff, Lee, Lowe, Macri, Monjarez, Marshall, McClintock, McIntyre, Mena, Morgan, Nance, Obrus, Orcutt, Ormsby, Ortiz Self, Parsley, Paul, Penner, Peterson, Paulette, Rammel, Reed, Reeves, Richards, Rude, Rule, Ryu, Salahuddin, Santos, Schmick, Schmidt, Scott, Shavers, Simmons, Springer, Stearns, Steele, Stokesbury, Stonier, Street, Stevie, Taylor, Ty, Theringer, Thomas, Timmons, Voles, Wallen, Walsh, Waters, Wiley, Ibarra, Zahn, Madam Speaker.
The previous, would the clerk please report the vote?
Madam Speaker, there are 57 yeas, 38 nays, 3 excused.
With that vote, the previous question has been ordered. Before we proceed to the final vote, one speaker in favor and one speaker opposed to the bill may speak. With that, are there further remarks in favor of the bill? The good member from the 30th District, Representative Reeves.
Thank you, Madam Speaker. I'm asking you to join me in support of inclusion by voting yes on this bill today, Madam Speaker. As you know, I represent the 5th most diverse school district in the country, where over 126 languages are spoken. The needs of students and parents in my district, Madam Speaker, are drastically different from home to home. The cultures are different, parenting styles are different. So I'm asking you to join me in voting for inclusion today, Madam Speaker. I'm also asking you to join me in voting to protect my rights as a parent. As you know, I have 2 children in the public school systems. I have every right to know what my kids are learning, to ensure that my kids as mixed-race children aren't being discriminated against in the public schools, Madam Speaker. And I have every right to know that when they show up to school every day, that they're safe. The bill before you ensures that my rights as a parent are protected. But I'm also asking you, Madam Speaker, to join me in voting yes for this bill, because as you know, and I know firsthand, parents aren't always the protectors that our children deserve. I know that my mom wasn't my protector, Madam Speaker, but do you know who was? Mr. Bob McCaffrey, my high school English teacher, who came in on Saturdays to make sure that I had a sandwich and a safe place to take respite from my house. You know who else was, Madam Speaker? Miss Nancy Reitinger, who, when I found myself sleeping outside at the age of 16 because my mom had relapsed into her substance abuse and had beaten me and kicked me out of my home, when she found out that I was sleeping outside, she made sure that I had a safe place to stay until I could figure out what to do next. You know who else, Madam Speaker, was there for me? Mr. Hank Buckman, who was our junior high custodian. And he made sure every single day that I got my free meal and that I got a safe space to download what was happening at home. Madam Speaker, I'm asking you to join me today in upholding parents' rights to ensure that we include all of our kids and to vote yes for inclusion.
Is there a further remark from someone in opposition to the bill? The member from the 19th District, Representative Walsh.
Thank you, Madam Speaker. Bad bill, vote no. Madam Speaker, we have considered from the beginning of this discussion to right now the many ways in which Senate Bill 5181 is a bad piece of public policy. Madam Speaker, this starts with the very title of the proposal and works down through most of the body of the text. Madam Speaker, when we developed Initiative 2081 that became the section of RCW 28A that it is now as good law, we heard from parents and families all around the state who spoke to me, to all of us involved, about what they saw as a fundamental change in our state's values. What they see is a system by which, in a series of small cuts and changes, our outstanding public education system has been undermined and debased into something that is incompetent at educating our children and puts us at a loggerhead with the state constitution, which charges us that our paramount duty is to deliver a high-quality basic education to all the children in the state. Madam Speaker, the families of Washington are watching that charge evaporate. And what they wanted in the Washington Parents' Bill of Rights was a restatement of our values. And Madam Speaker, you know this. When activist groups tried to attack the Parents' Bill of Rights in court after we passed it here, remember the vote, Madam Speaker. I remember it. It was 82-15 on this floor, and it was 49-0. It was unanimous across the rotunda. When the activist groups tried to attack the law in our state courts said it's good law. And that surprised some people. But they said it, Madam Speaker, because it is good law. And Madam Speaker, this is an inflection point. This is a point in our state's history when our state is going to change its direction and defend families.
The Speaker's time has expired. The question before the member from the 8th District, Representative Connors, for what purpose do you rise?
Madam Speaker, I move that engrossed substitute Senate Bill 5181 be laid on the table.
It's been moved and seconded that engrossed substitute Senate Bill 5181 as amended by the House be laid on the table. All those in favor say aye. Aye. Opposed say nay. The division has been called. The Speaker will open the roll call machine. The roll call machine has been opened. Has every member wishing to vote voted? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Will the clerk please take the record?
Madam Speaker, there are 38 yeas, 52 nays, 3 excused.
And with that, the motion is not adopted. The question now before the member from the 8th District, Representative Connors.
Thank you, Madam Speaker. I move to recommit engrossed substitute Senate Bill 5181 to the Education Committee.
It's been moved and seconded that engrossed substitute Senate Bill 5181 be recommitted to the House Education Committee. Remarks. The member from the 8th District, Representative Connors.
Thank you, Madam Speaker. I think we can tell by today this bill coming to the House floor isn't in a form that is ready to move off of the floor today. I think the wiser thing to do would be to recommit the bill back to the Education Committee where additional work could be done on the bill. We had it come this far, come out of the Education Committee, and you saw that amendments were actually accepted on the House floor today, which I believe could require further work than was done today, Madam Speaker. And so I respectfully ask that we recommit this bill back to the Education Committee.
Further remarks, good member from the 49th District, Representative Stonier.
Thank you, Madam Speaker. I move to call the question.
The previous question has been demanded. Do 1/6 of the members demand the previous question? Members who demand the previous question, please stand and remain standing. At least 1/6 of the members have demanded the previous question. The Speaker will now put the previous question to the House. An oral roll call vote has been requested. Will the clerk please call the roll? As many are as in favor of ordering the previous questions, say aye. As many are as opposed, say no. As many as are opposed to ordering the previous questions, say no. Please limit your comments to either an aye or a nay, and please rise when you vote. Will the clerk please call the roll?
Abarno. Abel. Barkus. Barnard. Berg. Bergquist. Birnbaum, Berry, Bernowski, Burnett, Caldeer. Callan. Chase. Connors. Corey. Cortez. Couture. Davis. Dent. Dolio. Donaghy. Duer. Defoe. Dye. Engel. Entenmann. Eslick. Farvar. Fye. Fitzgibbon. Fossey. Goodman. Graham. Gregerson. Griffey. Hill. Hunt. Jacobson. Keaton. Clicker. Levitt. Lakanoff. Lee. Lowe. Macri. Monjarez. Marshall. McClintock. McIntyre. Mena. Morgan. Nance. Obras. Orcutt. Ormsby. Ortiz Self. Parsley. Paul. Penner. Peterson. Paulette. Rammel. Reed. Reeves. Richards. Rude. Rule. Ryu. Salahuddin. Santos. Schmick. Schmidt. Scott. Shavers. Simmons. Springer. Stearns. Steele. Stokesbury. Stonier. Street. Stevie. Taylor. Ty. Theringer. Thomas. Timmons. Bowles. Wallen. Walsh. Waters. Wiley. Ibarra. Zahn. Madam Speaker.
Aye. Will the clerk please report the record?
Madam Speaker, there are 57 yeas, 38 nays, 3 excused.
Now the question before the House is whether or not engrossed substitute Senate Bill 5181 should be recommitted to the Education Committee. All those in favor say aye. Aye. All those opposed say no. No. The amendment is not adopted. Excuse me, the motion is not adopted. The question, the member from the 8th District, Representative Connors.
Thank you, Madam Speaker. I move that the rules be suspended on engrossed substitute Senate Bill 5181 and it be returned to second reading for the purpose of amendment.
It's been moved and seconded that the rules be suspended, that engrossed substitute Senate Bill 5181 be returned to second reading for the purposes of amendment. All those in favor say aye. Aye. Opposed say nay. No. The motion is not adopted. Now, the question before the House is final passage of engrossed substitute Senate Bill 5181 as amended by the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Does any member wish to change their vote? The correction with the Speaker's apologies, an oral roll call vote was requested on this. I just lost track of that. So we will vote by oral roll call. Will the clerk please take the votes?
Abarno. Abel. Barkus. Barnard. Berg. Bergquist. Birnbaum. Berry. Bernowski. Burnett. Caldeer. Callan. Chase. Connors. Corey. Cortez. Couture. Davis. Dent. Dolio. Donaghy. Dewar. Defoe. Dye. Engel. Entenmann. Eslick. Farvar. Fye. Fitzgibbon. Fossey. Goodman. Graham. Gregerson. Griffey. Hill. Hunt. Jacobson. Keaton.
We got it.
Clicker. Levitt. Lakanoff. Lee. Lowe. Macri. Manjarres, Marshall, McClintock, McIntyre, Mena, Morgan, Nance, Obras, Orcutt, Ormsby, Ortiz Self, Parsley, Paul, Penner, Peterson, Paulette, Rammel, Reed, Reeves, Richards, Rude, Rule, Ryu, Salahuddin, Santos, Schmick, Schmidt, Scott, Shavers, Simmons, Springer, Stearns, Steele, Stokesbury, Stonier, Street, Stevie, Taylor, Ty, Theringer, Thomas, Timmons, Voles, Wallen, Walsh, Waters, Wiley, Ibarra, Zahn, Madam Speaker.
Will the clerk please take the record?
Madam Speaker, there are 56 yeas, 39 nays, 3 excused.
Having received a constitutional majority, engrossed substitute Senate Bill 5181 as amended by the House is declared passed. The good member from the 21st District, Representative Ortiz Self.
Thank you, Madam Speaker. The Democrats will caucus in 20 minutes.
The good member from the 20th District, Representative Abarno.
Thank you, Madam Speaker. The Republicans will also caucus in 20 minutes.
House will be at ease for the purpose of caucus.
Walla Walla has to be one of my favorite places.